daily list for motion. Item number 1.
Lordship, this matter pertains to enforcement of the right of the petitioner to get family pension, 50% of family pension in respect of her deceased husband. Lordship, the matter was already decided by the civil court and even by this honorable court. The decision which was rendered by this honorable court is at page 35. At page 35, Lordship.
Yes.
In fact, it was a decision rendered by Lordship. One, Sri Rokamlava, also known as Rokama, he had left behind the petitioner, his wife, and he had also contacted some contact with other women during the lifetime, during the subsistence of the marriage between the petitioner and Rokama, and out of the said contact, one Sri Malsomzwala was born, and it was decided by this honorable court at page 18, page 50, at page, may I read from page 49, para 17.
Yes.
Three substantial questions of law were formulated by this honorable court, and the third is this at 17. In respect of the third substantial question of law, it may be seen that there is no dispute to the fact that the pension payable to the late government servant is covered by CCS Pension Rules 1972. Rule 54 deals with the family pension, and Rule 54.6 provides for the period for which family pension is payable to different members of the pensionary concern. There is no dispute to the fact that the appellant was legally married to the deceased government servant, and therefore, being the widow of late government servant, should be entitled to receive the family pension. It may, however, be seen that Rule 54.19 of the CCS pension rules provides as follows. 19. Eligibility of children from a void or avoidable marriage or family pension. The undersigned is directed to refer to this department's OM number so dated 2/12/1996, whereby it was clarified that pensionary benefits will be granted to children of a deceased government servant or pensioner from void or voidable marriages when their turn comes in accordance with Rule 54.8. It is mentioned in paragraph 4 of the OM that it may be noted that they will have no claim whatsoever to receive family pension as long as the legally wedded wife is the recipient of the same. The matter has been re-examined in consultation with the Ministry of Law and Justice Department and Ministry of Finance. It has been decided that in supersession of paragraph 4 of OM dated 2/12/1996, the share of children from illegally wedded wife in the family pension shall be payable to them in the manner given under sub-rule 7C of Rule 54 CCS Pension Rules 1972, along with the regularly wedded wife. Para 18. From the above abstract, it may be seen that the children from void or voidable marriage are eligible for family pension in accordance with Rule 54.8 of the pension rules. However, when the legally wedded wife of the government servant is the recipient of the pension, no claim can be made by the other class of family members eligible to receive pension. This, however, has been subsequently clarified by providing that a share of children from legally wedded wife in the family pension shall be payable to them in the manner given under sub-rule 7C of Rule 54 of the pension rules, along with the legally wedded wife. Therefore, besides the appellant, the son of the deceased government servant Malsom Zuala, who admittedly is a minor, would be eligible to receive 50% of the family pension. Therefore, substantial question number 3 stands answered accordingly. So, in that view of the matter, Lordship, the petitioner and Malsom Zuala, the minor son of the deceased from another woman, are to receive the family pension of the deceased in equal share, that is 50-50. And after disposal of this case, Lordship, the petitioner, through his counsel, had approached the authorities of the Directorate of Accounts and Treasury Department, Government of Mizoram, by submitting and by furnishing the judgment and order on 23/11/2022, which was duly received by the Accounts and Treasuries. And in spite of that, even after numerous reminders, nothing was in progress. And a number of letters been sent, and at page 56, your Lordship will see that there is a letter from the Deputy Commissioner to the Chief Controller of Accounts, letter dated 17 January 2023, at page 56, your Lordship. Sending of judgment and order. I have the honor to forward herewith judgment and order passed by the Guwahati High Court Aizawl Bench in RSN number so and so, passed by the trial court in airship certificate number received from Pu K. Laldin Liana, Advocate Counsel for the appellant, for your kind information and further necessary action from your end. And thereafter also in the year 25/8/2023.
Mr. Ramzao, please come to page 62.
Page 62.
62. This is a translation.
Yes.
This is from the Deputy Director of Pensions,
Yes, Deputy Director.
requesting the one Srimati Lorin Zwali to return the PPO.
Yes. If she is in possession of the same.
So they are aware about the order and they are in the process of taking some steps.
Your Lordship, after this, nothing was happening. This is a letter dated 6 May 2024.
Mr. Ramzao, one thing, this code in this RFA or RSA?
RSA.
RSA.
2 of 2016.
RSA says that held that the judgment of the additional district judge set aside,
Yes.
and heirship certificate number 71 of 19 is 71 of 2009 is upheld.
Yes.
Correct.
Yes.
Heirship 71 of 2009 was issued in the favor of one Nalrin Zwali and Melody.
That is so far as the claim in respect of GIS, DCRG and all that. And there's no dispute about that. We are not claiming.
What are you claiming?
We are claiming family pension only.
So here, if you come to page 17, this is the heirship certificate.
Page 17.
Yes. Annexure 2.
Yes. Yellow.
Serial number 1 is so-and-so, family pension.
Yes.
So you're not getting family pension here.
We're not getting family pension, but so far as this Melody Rosanzwali, daughter of the deceased, is concerned, she was given DCRG, SGE, GIS, and leave salary, etc. And so far as that is concerned, we have no dispute. And the matter had gone up to this Honorable Court even earlier by way of CRP number 4 of 2011.
No, what I'm saying is that you're claiming family pension.
Yes.
But family pension is in the name of Nalrin Zwali.
Yes, yes, that's
And this heirship certificate has been upheld.
true.
How is that?
That's it. Where is that?
The order passed by this court, page 53 says that the heirship certificate number 71 of 2009 is upheld. And that heirship certificate is in favor of Lalrinswali and Melody. This is slightly confusing. Where do you come in?
Yes, upheld, but in the light of the observations and findings arrived at by this court, as mentioned in the preceding paragraphs. This is how it was upheld. Upheld so far only in respect of the second matter, that is, in respect of the claim made by Melody Rosangswali.
I see, where is that finding?
The finding is, Lordship, if I come to page 46, para 13, these are the substantial questions of law. On 25/2/2016, this court, while admitting the appeal had formulated the following substantial questions of law. Number 1, Your Lordship,
Yes.
whether the learned law appellate court had rightly declared the respondent as the legal or real wife of the deceased, Rokama, in spite of no legal valid marriage between the deceased and the respondent. 2, whether the learned law appellate court was right in relying upon the unexhibited documents such as Maninlan Nalekha, dated 9/10/2008, familiarization card, and details of family declaration for holding that respondent is the real wife or widow of the deceased. 3, whether appellant, who is the only legal wife of deceased, is entitled to be given the benefit of family pension of the deceased as per law. So, all these issues have been discussed and decided in the subsequent paragraphs. Should I read, Your Lordship? Coming to the first substantial question of law, para 14.
Okay, the first substantial question of law is answered against the appellant. No, in favor of the appellant and against the respondent.
Yes. Now,
Favor of the appellant. You are the appellant.
I am the appellant.
So the substantial question of law was regarding whether
The learned law appellate court had rightly declared the respondent as the legal or real wife of deceased, Rokama.
okay, now things are okay. So now ultimately court says that the heirship certificate is upheld. This will be in respect of the second one, the Melody.
Yes, yes.
As for the first one, court has held that the appellant, the instant appellant, or the appellant or the petitioner in this case
Yes,
would be the legally wedded wife
yes, yes.
in
That
the
is
true sense of
finding.
term.
Yes.
So accordingly, the follow-up steps have to be taken. So this is the last communication, 6th May 2024.
That is true, Your Lordship.
Who are the parties here?
Parties, all of them are 1 to 6 are the state. Chief Secretary, Secretary Department of Finance, Chief Controller of Accounts, and Director Accounts, Deputy Commissioner Aizol, Treasury Officer. And 7, Srimati Lalrinswali,
Okay, the late government servant was working under which department?
in the DC Aizol,
Deputy Commissioner.
Deputy Commissioner.
Okay. So we'll issue notice on this note. Ms. Vanessiam, anything to say? Heard Mr. Seal Ramzao, learned senior counsel, assisted by Mr. Stephen Lalbotse for the petitioner, who submits that despite The decision taken by this court in RSA number 2 of 2016 that the instant petitioner is entitled to receive the pension. Family pension. The respondent authorities have failed to grant any pension to the petitioner. He submits that a copy of the court's verdict has been given to the respondents concerned, and but despite the same, no steps has been taken to grant the petitioner family pension. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. Vanesyami, learned government advocate, accepts notice on behalf of respondent numbers 1 to 6. Petitioner to serve requisite extra copies of the writ petition to the learned government advocate, if not already done. Stop petitioner to take steps for service of notice upon respondent number 7 by registered post with AD due within 3 days.
God bless.
For orders, item number 10.
Yes, what is this matter?
So,
My,
my lord, in this is
my lord, I'm appearing on behalf of my senior, and my senior is on, he's like on court number 2, so kindly pass over for the day, my lord.
Who is your senior?
Mr. Caesar Ramchana.
Okay. Yes. What is this matter?
so this is an application, my lord, for submitting of additional documents in the RFA.
Submitting
Additional evidence, my lord.
submission of additional evidence
Yes,
in the
in the
RFA.
RFA, in the connected RFA.
What are those additional documents?
This basically this is a land dispute, my lord.
Sorry?
The land dispute. So there are some relevant documents in the revenue department which were procured by the appellant. But these documents were not part of the, respondent. But these documents were not part of the court record, my lord. And so we believe that these documents would be important for the court. So we filed an application under Order 41. Order 41, Rule 27. And the other side have asked for time, my lord. And I think today they have been given a last chance, my lord. And I think they have not filed it in spite of being given a last chance.
Are you sure?
I'm not sure, my lord. I think the last occasion, I think there was some order to that effect. I'm not.
They have filed.
They filed. Oh, I've not been given a copy, my lord.
That's why I asked
I've
you.
not been served a copy. And, my lord, there is a Supreme Court judgment. Now, this Supreme Court judgment says, my lord, application under Order 41, Rule 27 CPC has to be considered at the final hearing, my lord. This is a judgment, my lord.
It has to be considered.
At the final hearing, during the time when the original RFA is decided, my lord, during that final hearing, this has to be considered.
What has to be considered?
The application
Under 41, Order 41, Rule 27.
Correct, my lord. There's a Supreme Court judgment, my lord, specific direction to that effect.
There's an acknowledgement slip here. Signature is there.
Sorry, my lord, actually we have, sorry, my lord, I've received
Laurin
it,
Sana
yes.
is the applicant.
Yes, we have received it, my lord, I'm sorry.
You have received it?
We have received it.
So anyway, let him come, since he's here, his own
Yes,
legs.
yes, yes, madam.
First of all, for the time being.
For admission, item number 2.
May it please the Lordship.
Yes.
May it please the Lordship. My Lord, in this review application on the last occasion, the respondent NBCC authorities, they filed an objection. I believe that objection is on records, my Lord.
Yes.
And yes, my Lord. And today, my Lord, Your Lordship, if my learned senior friend is ready, then we can start. My Lord, I can proceed with the advancement of this review application. I was told that he was not keeping well, my Lord, my senior. Yes, my Lord.
Yes,
I'll-
you are Mr. Thakur.
Yes,
My
yes,
lord.
Mr. Thakur was not keeping well, my lord. I was told by his junior, so just
Okay.
asking whether I should proceed, and he's okay today.
Yes, Mr. Thakur, what is your condition?
My lord, I am not very well, but so far as this case is concerned, we have been hard pressed by our client that something should be done at the earliest possible. But only we can praise only point of limitation. My lord, this case, the review petition has been filed after 30 days. Although we are not depending solely on that point, but it must be prayed by the petitioner that we have been delayed by this date and for this reason, and must explain the delay, which has not been done by the review petition. That is fatal for them. So 30 days is the limitation period. Even then, the courts in so many cases said that, all right, don't take the court for right. You explain why you have delayed for these days. They must do it. They must respect the court of the land. So that is my, because there are so many decisions of this court.
All right, that is on the technical side. What
That
about,
is the
Malad,
technical
what
side.
about on merit?
But, so far as the other review petition is concerned, the petitioner miserably failed to take any grounds on which point they want to take the review petition.
Okay,
Because this is a whole position of law since 2000 in Lily Thomas case.
all right, all right.
Union of India, Lily
Mr.
Thomas
Thakur,
versus Union of India.
Mr. Thakur,
Milord.
see, the court will hear you all, but it would be more convenient if both parties are present physically.
Yes, my lord.
There are some limitations through online.
So
Unless there
I have
are-
no objection.
unless-
Milord, only thing is that
Unless there is extreme hardship, will requiring accommodation, preference is to have a physical hearing.
Yes, my lord. Of course, my
Milord,
lord. Even I was also under, my lord, I was about to tell my senior also if he could come by any convenient date to conduct the hearing physically, my lord. It will be convenient for all of us, my lord.
if your lordship has any roster for Guwahati, that would be the best. Or else it may kindly be fixed in the first week of April, because I am going for further treatment to Chennai. Yes.
Now, first week of April may not be possible.
Milord.
Probably not possible in the sense that if you're not around, this court may be there in Guwahati for a few days,
My lord.
but thereafter back to Aizawl bench. You can have it next week, or court is available till 28th, if you can come down.
I'll be going to Chennai day after tomorrow. So it may take 7 days there.
Okay, so when can you come? Which is the convenient date for you then? How about 7th of April?
I have no problem, my lord. I have no objection.
7th of
My lord.
April.
Yes. My lord.
7th of
7th
April.
will be fine, my lord. 7th, I can come over to Aizawl,
Okay.
my lord.
No problem.
Parties are represented through VC. Please cancel that. Parties are represented by their respective councils and they appear through VC. Full stop. They submit that the pleadings are complete and that the matter may be taken up on 7th of April 2025. In view of above, list this matter on 7th of April 2025.
I'm highly obliged.
Item number 3.
Yes. Would you like to recapitulate what you had submitted yesterday?
Yes, my lord. Now, I'll come first to the CM Sundar case. CM Sundar case was pronounced in the light of Order 9, Rule 13.
Okay.
Now, Your Lordship will see that when the appeal was dismissed, not on withdrawal, thereafter, the parties cannot file for setting aside a decree under Order 9, Rule 13. That was the case decided in CM Sundar, which is not applicable in our case. Our case is distinguishable to the CM Sundar case, my lord.
No, in Siam Sundar's case, it's Order 9, Rule 13,
Yes, my lord.
correct? So, once the appeal is dismissed,
Yes,
one cannot file this application under Order 9, Rule 13.
correct, correct. my
That
lord.
is what
Yes, yes.
Siam Sundar said.
In our case, the genesis of the case is that we have filed Order 9, Rule 13 against the money suit judgment and order,
Ex parte.
ex parte. Now, without filing an appeal against that rejection of Order 9, Rule 13, we have filed an appeal against the original judgment and order in money suit. Now, it came before this Honorable Court by way of RFA, then RSA. Now, that things are not the same. The facts of the case are not the same with that of CM Sundar case. What CM Sundar case has enunciated is that when you have filed an appeal and it was dismissed, except on account of withdrawal of appeal, you cannot thereafter file for setting aside the decree under Order 9, Rule 13. So, my lord, in this case, in the interest of justice, the order, as directed by this Honorable Court, my lord,
In your case also, appeal was dismissed.
appeal was dismissed, but in CM Sundar case, appeal was dismissed, and after dismissal thereafter, they have filed an application for setting aside a decree under Order 9, Rule 13. Ours is preceded by an application for setting aside a decree. Thereafter, we have filed an appeal against the original judgment and order. So that is the difference. Now, if we look at the judgment and order passed by this court in RSA 124, this is Order 29/2024. This Honorable Court has observed that the appeal, it can be implied that the appeal was dismissed under Order 41, Rule 17, which is due to default. Now, that is against the case of the respondent here in Marot. It is the respondent now who has to be aggrieved by that order. Now, based on that direction, I have filed this FAO against the order dated 30/10/2023 under Order 43, Rule 1(3). So, by way of filing this appeal, I beseech this Honorable Court to set aside the refusal to restore or readmit the appeal based on what I have submitted yesterday, my lord.
So if your submission is accepted,
My lord.
you'll go back to that same
It
court.
will go back to the same court. And what my learned friend has stated,
And what have you stated before that court?
My lord.
Paragraph 2 or 3?
paragraph 2, my learned friend has skipped the other paragraph.
No, you have made a very brief application.
Yes,
isn't
correct,
it? Very
correct.
brief application.
Correct, my lord.
Saying that there was some sort of a miscommunication
Yes, my lord.
between the client and the counsel.
Correct. Now the order of this court is with me, my lord. I can take the order of this honorable court with me. Because this honorable court has made an observation and finding that it was dismissed on default.
Which observation is that?
In RSA 1 of 24.
On RSA 1.
Yes, yes. So I embrace that order. It is my learned friend that who is now aggrieved by that order. So I'm going to take that benefit, my lord.
It doesn't appear so. There's no appeal as such for the...
Yes. No, in the sense that he has made an oral submission yesterday. He's trying to impress upon this honorable court that he has to file again RSA against that 27/7/2023 order. That is the reason why I'm submitting that one.
Okay.
So in the interest of justice, let the order dated 30/10/2023, passed in CMS 672 of 2023, be set aside in the interest of justice, man.
Okay.
And Your Lordship may allow me to refer one page, my lord. In page 123. Not to save my skin, but to apprise this honorable court about the facts, my lord.
Yes.
Now, here there is an order passed by the District Legal Service Authority appointing Mr. 1 Saithangpui Silo to take up money suit case 138/2018. The reason why I'm referring this is because my name was mentioned in the judgment and order in money suit. It is way. Because initially I filed my vacca, thereafter I was replaced by legal aid counsel.
Where is it mentioned in the money suit?
My lord.
Where is it mentioned?
This is not mentioned, my lord. This order is not mentioned in the order.
No. Your name in the money
My
suit.
name is in setting aside in that. Wait. 165. My name would be there in page 102, 5822.
In the cost title.
Yes, yes.
Only this place.
And in 104. And
Oh.
in 105.
Copy to given to the... ...104 is a decree. And 105 is what?
This one is for this miscellaneous, which is filed under Order 9, Rule 13.
So you had not represented?
Yes.
You had not represented?
No, initially I have filed my vakalandama, then I was replaced by legal aid counsel. This can be seen from page 123, my lord, 11/8/20. So I'm bringing out this fact not to save my skin, but to apprise this honorable court about the facts, my lord.
You were replaced at what stage?
My lord, the order here is 11/8/2020. Order appointing Mr. 1 Saithangpuya. Now the impugn order,
11/8/2020.
yes, the impugn
Then
order,
the judgment and order was passed on 5/8/2020.
yes, because it was decreed ex parte.
No. You were replaced after the judgment was passed.
Yes. Now in CMA, my lord, CMA,
That means you appeared for the plaintiff
yes, during those
during the
time-
money suit.
Yes. In ex parte CMA, the order is 7/12/2021, page 105.
Of course, ex parte, setting aside the ex parte is a different person now, but during the money suit you were there.
Yeah, my name was there.
It's not that during the pendency of the money suit itself you were replaced, isn't it?
Yeah, correct. So I'm just bringing out the facts, my lord. So this is a case where no written statement was filed in the trial court. I took some blame for that, my lord. And where the appellant was not properly represented in the RFA, so in the best interest of justice, I beseech your lordship to set aside the order which refused to readmit the appeal, because I think that would be in the best interest of justice, my lord. If he is denied that opportunity, he is about to lose his immovable property, which would be in violation of Article 21 as well. That is my humble prayer, my lord.
Your Lordship, I'll make a short submission. Now, what we are looking at is the legality of that order dated 30/10/2023, my lord. And in pursuance of the order passed in RSA by this honorable court, the present appellant now preferred the present FAO, first appeal against order, my lord. And by looking at whether regarding the legality of the order dated 30/10/2023, my first submission is that, my lord, there is no wrong in that order, because the learned First Appellate Court had rightfully stated that it has to be challenged by way of filing second appeal only, even if the first appeal is dismissed on the ground of limitation. And it is correctly appreciated and observed in that case, CM Sundar Sharma case. And in order to further support my contention, my lord, I'll produce this citation. This is the Constitutional Bench, 1966, SCC. My lord, this is 1966 SCC online SC 98. I'll come directly to para 14. From this it is very clear, my lord. My lord, may I read this para 14?
Yes.
This brings us to the main point that has been urged in these appeals, namely that the High Court had not heard and finally decided the appeals arising out of suits number 77 and 91. One of the appeals was dismissed on the ground that it was filed beyond the period of limitation. Whether the other appeal was dismissed on the ground that the appellant therein had not taken steps to print the records. It is therefore urged that the two appeals arising out of suits number 77 and 91 had not been heard and finally decided by the High Court, and so the condition that the former suit must have been heard and finally decided was not satisfied in the present case. Reliance in this connection is placed on the well-settled principle that in order that a matter may be said to have been heard and finally decided, the decision in the former suit must have been on the merits, where, for example, the former suit was dismissed by the trial court for want of jurisdiction or for default of plaintiff's appearance, or on the ground of non-joinder of parties or misjoinder of parties, or multifariousness, or on the ground that the suit was badly framed, or on the ground of a technical mistake, or for failure on the part of the plaintiff to produce probate or letters of administration or succession certificate when the same is required by law to entitle the plaintiff to a decree, or for failure to furnish security for cause, or on the ground of improper valuation or for failure to pay additional court fee on a plaint which was undervalued, or for want of a cause of action, or on the ground that it is premature and the dismissal is confirmed in appeal, if any, the decision not being on merit would not be res judicata in a subsequent suit, but none of these considerations apply in the present case. For the additional civil judge decided all four suits on merits and decided the issue as to title on merits against the appellant and his father. It is true that the High Court dismissed the appeals arising out of suits numbers 77 and 91 either on the ground that it was barred by limitations or on the ground that steps had not been taken for printing the records. Even so, the fact remains that the result of the dismissal of two appeals arising from suits numbers 77 and 91 by the High Court on these grounds was that the decrees of the additional civil judge who decided the issue as to title on merits stood confirmed by the order of the High Court. In such a case, even though the order of the High Court may itself not be on the merit, the result of the High Court's decision is to confirm the decision on the issue of title which had been given on the merits by the additional civil judge, and thus in effect the High Court confirmed the decree of the trial court on the merits, whatever may be the reason for the dismissal of the appeals arising from suits 77 and 91. In these circumstances, though the order of the High Court itself may not be on the merits, The decision of the High Court dismissing the appeals arising out of suits numbers 77 and 91 was to uphold the decision on the merits as to issue of title, and therefore it must be held that by dismissing the appeals arising out of suits numbers 77 and 91, the High Court heard and finally decided the matter, for it confirmed the judgment of the trial court on the issue of title arising between the parties, and the decision of the trial court being on the merits. The High Court's decision confirming that decision must also be deemed to be on the merit. To hold otherwise would make res judicata impossible in cases where the trial court decides the matter on merits, but the appeal court dismisses the appeal on some preliminary ground, thus confirming the decision of the trial court on the merits. It is well settled that where decree on the merits is appealed from, the decision of the trial court loses its character of finality, and what was once res judicata against become res sub judice, and it is the decree of the appeal court which will then be res judicata. But the contention of the appellant were to be accepted, and it is held that the appeal court dismisses the appeal on any preliminary ground like limitation or default in printing, thus confirming toto the trial court's decision given on merits. The appeal court's decree cannot be res judicata. The result will be that even though the decision of the trial court given on the merits is confirmed by dismissal of the appeal on a preliminary ground, there can never be res judicata. We cannot therefore accept the contention that even though the trial court may have decided the matter on the merits, there can be no res judicata if the appeal court dismisses the appeal on a preliminary ground without going into the merits, even though the result of the dismissal of the appeal by the appeal court is confirmation of the decision of the trial court given on the merits. Acceptance of such a proposition will mean that all that the losing party has to do to destroy the effect of a decision given by the trial court on the merits is to file an appeal and let that appeal be dismissed on some preliminary ground, with the result that the decision given on the merits also becomes useless as between the parties. We therefore of opinion that where a decision is given on the merits by the trial court and the matter is taken in appeal, and the appeal is dismissed on some preliminary ground like limitation or default in printing, it must be held that such dismissal, when it confirms the decision of the trial court on the merits itself, amounts to the appeal being heard and finally decided on the merits, whatever may be the ground for dismissal of the appeal. So, my lord, it is apparently clear that even if the appeal was dismissed on the ground of limitation, then it has to be decision, it has to be taken as a decree. Then RSA is regular second appeal is invited, my lord, in order to challenge this, instead of applying for readmission. And I'll come to that, why readmission, filing of readmission should not be granted. I'll come to my next point, my lord. And even in this honorable court, while taking up the RSA 1 of 2024, there is, the order is particular, order is at page 37 of the memo of appeal, my lord. Page 37, para 16, even this honorable court had clearly observed that by pointing out Syam Sundar Sharma case, it says the Supreme Court held that when a condonation of delay, application is dismissed by the first appellate court, which results in the appeal being dismissed, a second appeal lies from the consequential order dismissing the appeal. I'll stop here, my lord. So why I'm saying this is that there is no illegality in the order of the learned first appellate court. Now I'm come to the technicality point first. The learned first appellate court said that, you have to file second appeal. You cannot file the readmission or restoration application because it was dismissed on the ground of limitation. So it has to be taken up as a decision on merit. It has to be taken up as an appellate decree. So there is no wrong or illegality, my lord. That is my first point. And now, let me come to the second point. There is the learned first appellate court's decision was that there is no sufficient ground for allowing the readmission, even if that has to be taken up as it is, my lord. By looking back what had already happened in the previous proceedings, money suit was filed and there was lethargy and lack of interest on the part of the present appellant. It was not, although he engaged a lawyer, a counsel, then he failed to file written statement by giving ample opportunity, my lord. Then due to that reason, ex parte decree was passed, and then thereafter, my lord, an application under Order 9 Rule 13 was filed. It was rejected, which by cutting short my submission, my lord, and thereafter, first appeal, the present appeal, RFA 5 of 2023 was filed, and due to default of appearance, due to non-prosecution, my lord, along with the application for condonation of delay, it was dismissed. And again, my lord, the very interesting part is that yesterday I failed to, I overlooked this particular point. Then today what I would like to say is that, my lord, even that application for readmission, restoration of the proceeding, my lord, appeal, it was barred by limitation, my lord. Because let me take your lordship to this particular paragraph, page, my lord. This is page.
Which application?
Application 672 of 2023.
672 was
Yes,
barred by limitation.
Yes, it was barred by limitation. I'll produce one citation saying that even though it was not set up as a defense from the opposite side, like from my side, then it is the court is bound to dismiss. Page 45, my lord. This is the application. Let me bring your lordship, kindly bring your lordship to page 45 first.
Page 45.
Yes, this is the application, my lord.
Yes.
Page 45 is an application, your lordship. Although there was no, in the course title, no provision was mentioned, but I will bring again your lordship to page 90.
What is the period of limitation?
30 days, as per
Okay,
the limitation act.
the order was passed on July
Yes, July.
27th precisely.
Yes.
Application was filed in the month of August.
No, my lord, it was filed only in the month of September, because the order is here.
How do you say that?
Page 91, my lord. May I
91?
kindly show page 91 of the memo of appeal. This is the order receiving the application, my lord. That is CMS 672 of 23. It was on 4th of September 2023. Only it was filed.
The order was filed on, order was passed on 4th September.
Yes.
But does it mean that it was filed on 4th of September? Because why I'm saying is this, because in the application
Yes.
for restoration, there's a verification. A verification column is there, which says that verified on dash day of August 2023.
August,
So-
it is left blank, my lord.
At any rate, you had filed an objection perhaps.
Yes.
Is it on record?
Yes, my lord.
Where is that? Against the application.
Page 55, my lord.
55.
Yes, 55.
Did you raise that ground that it was barred by limitation?
No, I didn't raise that ground. But, your lordship, if we look at section 3 of the Limitation Act, my lord, it is, and this can be supported by one citation. Section 3 says, my lord, subject to the provisions contained in sections 4 to 24 inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. It is true that, your lordship, I did not mention anything in my written objection regarding limitation period. But section 3 is very clear, and
No,
my
that
lord,
gives the liberty to the court. That gives the authority to the court to dismiss it. Supposing one application comes
yes,
beyond the period of limitation, opposite party makes an objection,
yes,
but not on limitation. Court can still say that, yes, this is barred by limitation, go on,
Yes.
dismiss.
exactly.
So this is the provision.
Exactly, ma'am.
But that process is over now. He did not plead condonation. You did not raise objection about delay. Court also did not say anything about it and simply passed the order,
Yes.
although rejecting it, but not on the grounds of delay.
Yes.
So in such circumstance, what would be the requirement?
Even the appellate court can exercise their power, my lord.
Where does it say that?
It should not be overlooked, my lord. Even this honorable court, once it is,
No, but
although,
is the appellate court there to cure all the defects? Or if the things are not raised by the parties at the relevant time?
because even if it is not raised, my lord, the court has to look into that limitation issue. I have one citation, my lord. This is. I'm sorry that I failed to prepare the citation memo, my lord, but I'll produce this, only this citation. This is 2022 SCC on 9. Sorry, my lord.
Which one?
Yes, my lord. This
Shivraj
is
Reddy?
2024 SCC online. Shivraj Reddy. I'll come to para 16. 16 and 18 are relevant.
16 and 18?
16, yes.
Yes.
Para 16 says, my lord, thus it is a settled law that even if the plea of limitation is not set up as a defense, the court has to dismiss the suit if it is barred by limitation.
Just pause there.
Yes.
The court, that
Yes.
means which court? This will mean the court of, that court, not this court.
I understand.
Because
I have, yes.
it, at the very phase of it, when it is seen that it is time barred, although opposite party has not raised any defense saying that it is time barred, court will dismiss it because of section 3. But court has not dismissed it. Neither has the party raised objection, neither the party has made for condonation of delay application or any objection has been raised. Court has also not gone into that aspect. So
yes.
you are asking this court to travel back to that stage.
I understand what your lordship is saying, my lord. I have come across one judgment, I'm sorry that I could not produce it right now, that even at the appellate stage, that issue can be dealt with, my lord. Because section 3 is very clear, it is self-explanatory. So because even if Lalanet First Appellate Court didn't touch upon that issue of limitation, but still this honorable court at the appellate stage can still look into that matter, my lord. So because why I'm saying is that it is the manifestation of the lethargy on the part of the present appellant. Because due to the delay and due to the negligence, he has come up to this extent, my lord, to the extent of this level. All dismissed due to disinterestedness, due to lethargy on his part. And even by filing of the application for readmission, presuming it was dismissed on the ground of limitation, not default. But still, the last application was also still barred by the limitation, my lord. So these two main grounds pointed out by the Lalanet First Appellate Court, saying that there is no sufficient ground. Because in his application, by leaving aside that limitation issue right now, my lord, if we look at that particular paragraph number 2, he has made a mere statement in a short para without accompanying or supported by any evidence saying that it was due to miscommunication between the counsel and the appellant, only that he failed to appear. Then there is no sufficient ground for granting the application for restoration. And on the top of that, my lord, regarding the technicality, it is very clear that he should file the second appeal. So with this, now by examining the legality of the order dated 30/10/2023, it may kindly be dismissed, the present appeal, my lord. So because why I'm saying is that, my lord, even if it is dismissed, then he will still be having, the present appellant is still having a liberty to file the second appeal for the second time, because the second appeal which was dismissed by this honorable court, it wasn't decided on merit. So there is no question of res judicata coming into play. So it is the same thing. He will file again second appeal again. So there is no harm. There is no, his interest will not be prejudiced.
Okay.
With your lordship permission, may I be allowed to counter my learned friend's submission, my lord?
Please be brief.
Yeah, I understand. Now, my lord, my learned friend is now aggrieved by the order 30/10/2023.
You are the applicant. Can you point
Yes.
out which date you had filed? On
No,
which date you had filed?
Not now, but it was admitted by the court.
No, that we know. The
Yes,
order
my
is
lord.
there.
Yes. Now,
The order is there. It speaks for itself.
yes, correct, my lord.
But since you were the applicant, can you tell us on which date exactly did you file?
As of now, I cannot point out the precise date because I was not there in the first appellate court. And
See, that cannot be the ground, Mr. Faxwala.
yeah, I know that, my lord.
I was not the
Pardon.
counsel. I was not present.
I should not have
Those
said
things, those things are not an excuse.
that. Yes, my lord.
When you take up a brief, when you take the brief of a client, that means you take the full responsibility
Correct,
right from day one.
I agree.
If the court wants to go back to the previous dates, you have to be fluent with that. You have to have all the informations with you,
Correct.
what had transpired, and not say that Mr. XYZ was the counsel, I don't know what he did, I don't know.
Since-
Today I am the counsel, I know what I do.
Correct.
You can't say that.
I agree with your lordship. Since my learned friend has caught me a surprise with that order 30/10/2023 regarding condonation of delay, which was not raised in RSA also. And my learned friend has skipped again that paragraph number 15 of the RSA order 29/2024, which clearly states my case.
All right.
If I may be allowed to produce one citation, my lord,
On what?
on regarding
This is not enough, all these citations.
regarding the applicability of a particular case to another case.
Give me the citation.
It's in item number 8.
Huh?
I propose to rely this judgment in item number 8. I'll just give this.
Give me the citation.
2008-16 SCC 14.
2008-16.
16 SCC 14. 14.
14, page 14. Paragraph?
Para 7, there is page 21. And para 15, 16, 17, para 22.
What does it say?
In para 15, placanta B, the ratio of any decision must be understood in the background of the facts of that case. It has been said a long time ago that the case is only an authority for what it actually decides and not what logically follows from it. At para 16, it is also well settled that a little difference in facts or additional facts may make a lot of difference in the precedential value of a decision.
Citations there? It's okay, I'll find it out.
That let the order 30/10/2023 be set aside because the issue of limitation will always be there in the first appellate court, which was raised by learned friend at this stage. That is my humble prayer.
Okay. You heard Mr. C. Lal Faxola, learned counsel for the appellant, and Mr. B. Lal Ramayana, learned counsel for the respondent. By filing this appeal, under Order 43, Rule 1, bracket small t, T for Tripura, of the Code of Civil Procedure, 1908, bracket CPC. The appellant seeks for setting aside the order dated 30/10/2023, passed by the Learned Additional District Judge, Roman 2 Aizol, in CMA number 672 of 2023, arising out of RFA number 5 of 2023. By which the application for restoration of RFA number 5 of 2023 and the connected CMA number 160 of 2023 was rejected and dismissed. Was rejected and the application dismissed. Next para. Brief facts of the case is that money suit number 138 of 2018 was filed by the instant respondent. See, I'm on the facts. If there's some distortion in the facts, you let me know.
Hello.
See, where's the money suit order?
102, page 102.
102.
102 and 103.
Claiming an amount of rupees 5 lakhs. From the instant appellant. No, one thing is this is recovery for 16 lakhs.
Yes, Malad.
But why 5 lakhs only?
He has given only 5 lakhs.
Okay, you cancel that amount, okay? Claiming an amount of 5 lakhs, you cancel. Amount of rupees 16,80,000 from the instant appellant. Stop. The money suit was
Page 105, Malad.
disposed of by judgment and order dated 5/8/2020, and a decree was passed ex parte. Stop. Against the same, the present appellant filed CMA number 213 of 20. For setting aside the ex parte order and decree dated 5/8/2020. But however, the application was rejected and dismissed by order dated 7/12/2021. To stop, next para. The appellant, being aggrieved, filed RFA number 19 of 2022 before this court, along with an application for condonation of delay, that is IA bracket C number 80 of 2022. Full stop. Although the delay was condoned by this court, the matter was remanded back for consideration by the district judge on account of pecuniary jurisdiction. To stop, the order was passed in the RFA on 2/11/2022. Next para. Pursuant thereto, the appellant filed RFA number 5 of 2023 along with CMA number 160 of 2023 for condonation of delay in filing the said appeal. Full stop. The lower appellate court, however, refused to condone the delay and dismissed the application for condonation of delay, white order dated 27/7/2023. Full stop. In view of the rejection of the application for condonation of delay, the appeal also was dismissed as barred by limitation. Next para. The appellant, being aggrieved, filed RSA number 1 of 2024 before this court under section 100 CPC, challenging the order dated 27/7/2023. Passed in CMA 160 of 2023 and in RFA number 5 of 2023.
May I interject, my lord?
Yes.
Before that, we have filed CMS 672 before filing RSA.
Okay. Put a star mark where you've written RSA. Go to the next paragraph. The appellant, being aggrieved, with the dismissal of the CMA application, CMA number 160 of 2023 and the RFA number 5 of 2023, filed an application for readmission stroke restoration of the same white CMA number 672 of 2023. Stop. However, the said application was rejected by the learned court below, white order dated 30/10/2023. This you insert there, okay? Now after that you come to the star mark. The second appeal was taken up for consideration on 2/9/2024, and this court, after hearing the parties, was of the view that it can be implied that CMA number 160 of 2023 had been dismissed under Order 41, Rule 11 or Rule 17 CPC. Stop. That although the appellant had the opportunity to file a second appeal on the rejection of CMA number 160 of 2023 and RFA number 5 of 2023, the appellant had availed the provisions of Order 41, Rule 19, CPC, for challenging the impugn orders dated 27/7/23. Therefore, the court opined that unless the appellant makes a challenge to the impugn order dated 30/10/2023, passed in CMA number 672 of 2023, the appellant cannot make a challenge to the order dated 27/7/2023, passed in CMA number 160 of 2023 and RFA number 5 of 2023. Since there was a clear provision to file an appeal under Order 43, Rule 1, bracket small t, CPC. Accordingly, the second appeal was dismissed. Next para. Pursuant to the dismissal of the second appeal with the observation that was made, the appellant has filed the instant appeal by invoking Order 43, Rule 1, bracket small t, CPC. Mr. C. Alfaqzola, Learned Counsel for the appellant, by referring to the Memorandum of Appeal, submits that the learned court below while passing the impugn order dated 30/10/2023 had failed to satisfy itself and appreciate the fact that the appellant was not properly represented by his counsel in prosecuting the case before the trial court or before the appellate court. He submits that there are no materials available to show that the appellant had voluntarily absented himself or he was negligent for not appearing before the court at the time of hearing. He submits that from a perusal of the order sheet, dated 21/4/2023, 25/5/2023, 26/6/2023, and 26/7/2023, it can be seen that the appellant was neither summoned by the court nor was informed by his counsel to appear before the court. Stop. In fact, the learned court below ought to have invoked Order 5 Rule 3 CPC, summoning the appellant to appear personally in case of failure by his counsel to represent him on several occasions. Stop. The same not having been done, the impugn order dated 30/10/2023 has caused grave prejudice to the appellant because if the appeal is not readmitted or restored to file, the appellant is bound to suffer irreparable loss and hardship. And also would result in gross infringement of his fundamental rights. First off, the learned counsel also submits that the learned court below, instead of having an independent consideration on the case projected by the appellant, has simply relied upon the earlier order passed by the predecessor court on 27/7/2023 in CMA number 160 of 2023 and in RFA number 5 of 2023. Stop. The learned counsel also submits that although the learned court below had relied upon the decision of the apex court rendered in Shyam Sundar Sharma versus Panna Lal Jaiswal and others, reported in 2005-1 SCC 436, the same would not be applicable to the case of the appellant. There is no similarity on the facts. Stop. Referring to the said decision, the learned counsel submits that, according to the apex court, the High Court had rightly held that a petition under Order 9, Rule 13, CPC, would not lie in view of the appeal already filed by the same party had been dismissed, whether it be for default or for any other reason except for withdrawal. Stop. The learned counsel submits that in the instant case, the appellant, prior to filing the appeal, had filed CMA number 672 of 2023 for readmission of CMA number 160 of 2023 and RFA number 5 of 2023, which however came to be rejected via order dated 30/10/2023. It was only thereafter that the appellant had preferred
My Lord, may I interrupt? It should be CMA number 213 of 2020, because that was the order passed in under Order 9, Rule 13.
or not 672. You had
No.
filed,
CMA 213.
okay.
CMA 672 happened thereafter, my Lord.
Please read the last line, last paragraph. However, in the instant. No. The beginning of the sentence. Okay, CMA number what? How much?
213 of 2020.
You can from number you cancel after number. Had filed the rest you cancel till the bottom. Had filed CMA number 213 of 2020 under Order 9,
Order 9, Rule 13.
Rule 13 CPC for setting aside ex parte order, which however came to be rejected via order dated 7/12/2021. It was only thereafter that the appellant preferred RFA number 5 of 2023 along with CMA number 160 of 2023. Such being the position, the case cited and relied upon by the learned trial court would not be applicable to the case of the petitioner, appellant. Full stop. The learned counsel submits that You had referred to 2008, volume 16,
Yes, my lord.
page 14.
Page 21, my lord. Page 21, para 7.
Submits that the ratio of any decision must be understood in the background of the facts of that case, since it is an established principle of law that a case is only an authority for what it actually decides and not what logically follows from it. Stop. In support of his submission, learned counsel relies upon the case of Ambika Quarry Works versus State of Gujarat, reported in 1987, 1 SCC 213, which was again relied upon by the Apex Court in Deepak Bajaj versus State of Maharashtra and another, reported in 2008, 16 SCC 14. Stop. The learned counsel therefore submits that the impugned order dated 30/10/2023, having been passed without giving due consideration of the case projected by the appellant, the same should be set aside and the matter remanded back for fresh consideration. The learned counsel, in support of his submission, has relied upon the following authorities. Number 1, Sangram Singh versus Election Tribunal, Kota, and another, (1955) SCC Online, SC 21. Number 2, Bank of India versus Lekhi Monidas and others, 2000, Volume 3, SCC 640. Number 3, Judgment dated 5/2/2019, passed by the Supreme Court of India in Civil Appeal number 1463 of 2019, arising out of SLP bracket C number 23718 of 2018, open bracket, the Commissioner, Mysore Urban Development Authority versus SS Sarvesh, close bracket. What were the other citations?
2008, volume 13.
Okay.
SCC.
Next, Secretary, Department of Horticulture, Chandigarh, and another versus Raghu Raj, 2008-13 SCC 395. Next. State of Nagaland versus Lipok Ao and others, 2005, 3 SCC 752. Hmm?
1998,
What about 2013 one? Tukaram?
Yes, my lord.
Okay, Tukaram, Kana Joshi and others versus Maharashtra Industrial Development Corporation and others, 2013, 1 SCC 353. Any more left?
1998, 7 SCC 123.
1998.
Yes.
Did you give the book?
I think yes, my lord. Is there, my lord.
N. Balakrishnan.
Yes, that is with regard to condonation, my lord. Delay.
This is the last one?
Yeah, last one.
And number, you give the number. N. Balakrishnan versus M. Krishnamurthy, 1998, 7 SEC 123. What is the para?
Para 9. 11, 12 and 13.
All right, just rise for 5 minutes and come back. Next para, Mr. Bilal Ramega, Learned Counsel for the respondent, on the other hand, submits that no sufficient ground has been shown by the appellant for restoration of the application for condonation of delay and the connected appeal. Stop referring to the pleadings made by the appellant. The learned counsel submits that all that has been mentioned by the appellant is that there was some sort of a communication gap between the client and the appointed counsel. And the same is without any substantiation or any documents to support such claim. So, therefore, the impugn order dated 30/10/2023 was rightly passed by the learned lower appellate court. Full stop. He further submits that the case of Shyam Sundar Sharma is squarely applicable to the instant case. And in fact, the dismissal of the application for condonation of delay amounts to dismissal of the appeal itself, since the order being challenged in the said appeal only gets upheld by the dismissal of the application for condonation of delay and also the appeal. Stop. He otherwise submits that the application for condonation of delay was dismissed for want of sufficient cause being shown by the applicant as to why the delay had occasioned, whereas the appeal was dismissed as being barred by limitation. Stop. Referring to the order dated 2/9/2024, passed by this court in RSA number 1 of 2024, the learned counsel submits that this court also had observed that a second appeal would lie from an order dismissing the application for condonation of delay and therefore the appellant ought to have filed a second appeal challenging the rejection of the CMA number 160 of 2023. Arising out of RFA number 5 of 2023. He submits that since the earlier second appeal was not disposed of on merit, a second appeal would be maintainable and will not be barred by the principles of res judicata. The learned counsel has relied upon paragraph number 8, 9, 9.1, 10 and 15 of Shyam Sundar Sharma Supra. In support of his submission. Stop, next para. The learned counsel also submits that, in fact, CMA number 672 of 2023 was also time barred and that even if an objection on this ground had not been made by the respondent, but yet in view of Section 3 of the Limitation Act, such time-barred application would not be maintainable and should be rejected. He submits that the respondent also cannot be precluded from raising such a ground even at this stage. In support of his submission, the learned counsel relies upon the case of S. Shivraj Reddy versus S. Raghuraj Reddy and others, reported in 2024 SCC Online SC 963. And also the case of Shiodan Singh versus Daryau Kumar, reported in 1966 SCC Online SC 98. Stop. Next para. The learned counsel further submits that from the sequence of events right from the filing of the money suit, it can be plainly seen that the appellant has been negligent in not availing remedy available to him on time. In view of such callous attitude, the learned courts below had rightly rejected the claim of the applications filed by the appellant by refusing to condone the delay which otherwise were not explained to the satisfaction of the court below. Mr. Ramega, anything else you want me to add?
Your Lordship, this 1966 SCC online, it is in the same line with that regarding second appeal, filing of second appeal, not on the question of limitation, my Lord. Shyam Sundar Sharma case, it is similar to that case, my Lord.
It's okay, we have referred
Yes.
it. We'll take into account all those aspects. He thus submits that under the given facts and circumstance, the impugn order dated 30/10/2023 does not call for the interference by this court, and the appeal should be dismissed. He also submits that even with the dismissal of the instant appeal, the appellant is still not prevented to prefer a second appeal
Yes.
against the order dated 27/7/2023, passed in CMA 160 of 2023, arising out of RFA number 5 of 2023. Okay, these are the facts I have
Yes.
just jotted down. This will be CAV.
Much obliged.
Hello, obliged.
You prepare a separate order, okay? Heard so-and-so, so-and-so. Hearing concluded, judgment reserved.
Your Lordship, I have inquired from the department with regards to the
With regard to what?
item number 4.
This case. We are not done with this case. Just a minute. You wait. Have you called out the matter?
Yes, my lord.
You are in a hurry.
No, my lord.
Let the court master call out the case, then we'll see. Not required.
Item number 4.
Yes, my lord.
Yes, now you say. What are you saying?
Yes, my lord. I have not yet received the parawise comments. The department have sent it to the law and judicial for vetting. So if your lordship can grant me another 3 weeks time for filing my affidavit in possession.
Okay. How much time you require?
3 weeks
3
time,
weeks.
my lord.
Okay, parties are represented by the respective counsels. Ms. Caroline K. Lumoipi, learned government advocate, submits that she is yet to receive the instructions and parawise comments from the department, and therefore prays that she may be granted further 3 weeks' time. To file the counter affidavit in view of above. Matter stands adjourned for 3 weeks. Respondents to file their counter affidavit in the meantime.
Item number 5.
Obliged.
Yes,
My pleasure, Lordship.
yes.
My Lord, in this matter, I did not get the instructions as of yet, my Lord, so I may be given some more time, my Lord.
But last time Ms. Vanessiam had appeared.
So, yes, my Lord, this particular case has been just endorsed to me, just recently endorsed to me. So,
Have you read the last order?
yes, I have read the last order. My
What
lord.
does it say?
To get instructions with regard to the ongoing attempt for the amicable settlement.
You have no instructions.
No instructions as of yet, my lord. And this particular case has been endorsed to me just recently, my lord.
Okay. How much time should you require?
3 weeks, my lord.
Okay, please write down. None appears for the petitioner when the matter is called. Stop. However, Mr. Benjamin Lal Samwana, learned counsel, learned government advocate, appears for the state respondents. And he submits that he has recently been entrusted with the case brief and he may be granted 3 weeks' time to obtain instructions in the matter. Stop. Next para. Peruse the order dated 30/1/2025, wherein it was submitted to the court that the parties are attempting to arrive at a settlement out of court. And the process is an ongoing process. So stop. Such being the position. No, not such being the position, cancel that. Next para. In view of above, the matter stands adjourned for 3 weeks. Parties to inform the court about the status of the settlement by the next court date.
Obliged, my lord.
Item number 6.
My lord, in this case, my lord, I have submitted the affidavit on behalf of State Respondent 1 to 4 in the main case, my lord. And however, my lord, there is a recast petition, so I may be given time, my lord, to obtain instructions.
You say that affidavit was filed,
My lord, in
but
the
not on the recast.
my lord.
There's an amendment.
My lord, there is a recast petition, my lord. But in last court date, the government council had submitted that they are not filing the counter affidavit.
No, it's not that.
There is newly implemented respondents, my lord. Instead of that MSSB, the MPSC is impleted, my lord. So they are filing their affidavit.
No, whom have you pleaded?
MPSC, my lord.
MPSC as
MPSC.
respondent number?
Respondent number 53.
53.
53.
So, anything else was what was the amendment about? Just for implement?
Just for implement, my lord, yes.
No other facts?
No other facts.
So, Mr. Benjamin, what will you file affidavit then?
My lord,
If it's only implement of one party, one more party?
I understand, my lord. With regard to that, my lord, I may be given time to obtain instructions, at least, my lord.
Ms. Dinari, what is this matter?
I have filed my affidavit.
Oh, you are appearing on for which respondent?
For the private respondents.
Number?
Number 6 to 52.
6 to 52.
Yes.
And Mr. Benjamin is for 1 to 5?
1 to 4, my lord.
1 to 4.
Who is number 5?
5 is the MPSC.
Huh?
MPSC.
But MPSC, Mr. Efla Lengnia says is respondent number 53.
Yeah, maybe.
Yes, my lord.
What do you mean, yes? Can you implead MPSC as respondent number 5 and also as respondent number 53 in two places?
Respondent number 5 is already MSSB, my lord.
Huh?
MSSB. That was terminated. That Mizoram.
Okay.
So, as the Mizoram Subordinate Staff Selection Board was terminated, my lord. So, we prayed time for implement of the MPSC.
Okay.
So, instead of putting the MPSC as a respondent number 5.
What is the name?
MSSB, Mizoram Subordinate Staff Selection Board.
Board. So, Ms. Dinari, 5 is not MPSC, 5 is MSSB.
MSS and 53
So-
is MPSC.
That is why I was thinking, why you have to implement in two places, as 5 and 53. So, the respondent number 5 has nothing to say.
Nothing to say, my lord.
Now MPS has been impleted,
Yes, yes, my lord.
and you have filed recast,
Yes.
with only one change,
What-
respondent,
By impleting only the MPSC, my lord.
nothing else.
Nothing else.
So what is there to counter now, Mr. Benjamin?
Lordship, I understand, but to be on the safer side, I might be given time to obtain obstruction.
It's delayed since, my lord.
Mrs. Dinari, anything you have to say regarding the implement of the new party?
Your Lordship, you said that it is not enclosed, but I have a file again, the reply.
See,
There's some enclosure also recast.
what is that?
Case 108, judgment, he enclosed some judgment.
Which one? Show
In
me,
the
page number,
recast petition,
page number.
page number 15, annexure 2.
How many times you have filed recast petition? How many times?
My lord,
There are two recast petition here,
Yes.
both filed on different dates.
And these,
One is 31/5/24 and one is 12/11/24.
2 times, my lord.
2 times.
2 times, yes. This
So-
is the second time,
Second time.
yes.
So what was added in the first time?
That in the first time, the petitioners are impleted, my lord. Petitioner only, there is only one petitioner.
Petitioners
In
are
the first
impleted means
instance.
what? You are the petitioner. You are impleting yourself. What do you
Petitioner
mean?
number 2 to 8 are impleted, my lord.
Some more petitioners.
Some more petitioners, yes.
Okay, say that.
And after that, the recast petition was submitted, and then again, the MPSC was impleted as respondent number 53, my lord.
Let us see the original petition. How many petitioners were there initially? Initially, how many petitioners?
Initially, my lord, before impleting the petitioner number 2 to 8, there is only one petitioner.
Are you sure?
Yes,
I see there are already 9 of them in the first writ petition. There are already 9 petitioners
now, yes, 9 petitioners, my lord.
in the first writ petition.
In the first writ petition, which is filed on, my lord, July 2023.
14th of July,
Yes, my lord.
precisely.
Yes, my lord.
There are already 9 of them as per the original writ petition. Or did you change the cause title?
There may be a change in the cause title only, my lord.
Your Lordship, yes. After holiday, in the meantime, you can take instruction
My lord,
by
here,
the state.
my humble submission is that, my lord, the state council already had submitted that they will not file their counter affidavit, my lord. So with this,
my lord, as per the order dated 18/2/25, I believe this is the last court date, my lord. So this is in a para number 3, my lord. From, yes, my lord. If I may read, my lord, Mrs. Vanessa Milanet, government advocate, also submits that they have also filed their counter affidavit. This, I believe this is in the main, first petition, my lord.
no, my lord, that is after submitting the recast petition. After submitting the recast petition.
Okay, let us forget about all these things. Now, what is the issue regarding here? What are you challenging?
The issue is with regard to the promotion order of the health workers who are promoted to the health supervisor, my lord. By filing this petition, I am challenging the office order dated 11 July 2023, selecting the female health workers who are promoted to the post of health supervisor, my lord.
Okay.
Initially, the notification was issued for filling up the post of health workers, my lord. And
Where is the promotion order you're challenging? Page?
office order is at page 28.
28.
28.
Where's the type copy?
The type copy is at page 30.
Prior to this order, there was a recommendation, isn't it? Result. This is by LDE,
Yes.
Limited
yes,
Departmental
yes,
Examination.
Yes, my lord.
So page 24, annexure D is the LDE result.
Yes, my lord. This is the
And
result.
pursuant to this result, this office order has been issued.
Yes.
Correct?
my lord. Correct.
And the LDE was conducted by the Staff Selection Board.
That MSSB, my lord. Yes,
Exactly.
That's
Staff Selection Board, I think.
Yes, my lord.
What is the full form? Mizoram?
Mizoram
State.
Subordinate
Or
Selection.
Mizoram Subordinate?
Services Selection Board.
Okay, Mizoram Subordinate,
Staff
Services-
selection.
Subordinate service, my lord.
see, even in that full form, you're not agreeing. Both sides are not agreeing anything. Mizoram Subordinate Service Selection Board.
Here in the annexure, my lord, written in my petition, in annexure B, at page 22, notification was issued by the Secretary of the MSSB, wherein it was written that Mizoram Subordinate Services Selection Board.
Okay. Okay, we'll just say Selection Board. Okay, now Selection Board is not required anymore. Why have we
It
implemented
was
MPSC?
terminated, my lord.
Sorry?
The functioning of the MSSB was terminated.
Okay. They have done what they had to do. They made recommendation, government has made appointment. Now they are defunct now.
They are defunct now.
So why do you implement MPSC, for what reason? What will MPSC do? They will say that we have not made the selection, unnecessarily we have been implemented as a party. What was the idea behind implementing
The
MPSC?
idea behind is in the event of making any direction for
Reconsideration.
consideration of the
Okay,
LD.
okay, so it's a
LDR.
by way of abundant precaution.
Yes, my lord.
Okay. So they have implemented MPSC and you want to get instructions.
My lord.
Why MPSC should be a party or not?
My lord.
They're already a party. Respondent number 30, how much?
35, 50.
53.
53.
53.
Okay, anyway, we'll give you time,
My
give you
lord,
instructions.
my lord, Mr. Nunsanga is also appeared online, my lord.
Yes,
So
he's sitting in
presenting
library.
the MPSC.
Where are you?
My lord, one thing I would like to submit is that I have not been given copy of counter affidavit files by the government. So, and that is one thing. And one more thing is that, my lord, this is our second appearance. So we have filed this morning. So a copy of our counter affidavit also was given to the parties.
You are for the MPSC?
Yes, Your Lordship. Actually, MPSC was designated to assume the work, the conditions of that one, this one, MSSB, since February 2024. So might be because of that, since that MSSB has been dissolved in
But,
February.
okay, do you have anything to say otherwise in this case?
Actually, that time we are not involved much. So in case this court pass any order, so then we might be so helpful. Otherwise, so what they have done already by MSSB, we cannot justify much.
Obviously, it was the board who made the selection. So they are the best person to know. It's already defunct. If the writ petition is dismissed, you have nothing to say.
Yes.
If it is allowed, then maybe you'll have to do some exercise. So at any rate, we'll grant the parties some time. whatever it may be. If you want to file, you file. If you don't want to file, don't file. And how much time should you require?
Lordship, after vacation, my lord, 2 weeks. 3 weeks, my lord.
Mr. F. Lengdina.
My lord, the matter is delayed since 2023, my lord. So the selected incumbent had already joined their post. So any favorable order in favor of the petitioner may be not helpful if the matter is delayed, my lord. So attempt may be made to dispose of the matter within a short time.
What to do? You keep on filing recast petition, that's why. You stop filing recast petition, then we'll put a stop to the thing and hear the matter.
So
If you file one more recast petition, again we'll have to give him some more, give them some more time.
that is the, the future contingency situations, my lord. Because
Anyway,
of that,
thing is that they also have a right to get instructions and file their counter affidavit because of the recast petition. So we don't know what is there in the recast, but since they want some time, we'll grant them. Okay, please write. Parties are represented by the respective councils, including the MPSC. Full stop. The learned counsel for the respondents submits that since the petitioners have filed a recast petition for the second time, some time may be granted to get instructions on the same. Full stop. Mr. J.C. Nunsang, a learned standing counsel MPSC, also submits that he has not received a copy of the counter affidavit filed by
The state respondent.
the state respondents. Mr. Benjamin, you give a copy. Is there anybody here to receive the copy?
Yes, Your Lordship, my junior is there, Arkia.
Okay.
I will, my lord.
Learned State Council shall furnish a copy of the counter affidavit by tomorrow to the MPSC. Stop. As paid for by the learned counsels for the respondents. No, before you cancel that. Mr. F. Lengdiana, learned counsel for the petitioners, submits that since the matter has been pending for quite some time, he prays that the case be taken up early for consideration. For stop considering the submissions made, let the matter be listed again after 3 weeks on a date to be fixed by the registry. Respondents to file their counter affidavit in the meantime. So, since the petitioners have expressed urgency, an attempt shall be made to take up the matter for final disposal on the next date.
Obliged, my lord.
Item number 7.
Yes, what is this?
Lordship, again, in this matter, I do not receive any instruction as of now, my lord. So, if I may be given some more time, my lord.
My lord,
yes.
it's been 1 year since we have filed the instant revision petition, and the government has not filed any affidavit till date. So if he wants to take instruction, let him take telephonic instruction, and on whether they want to file affidavit or not. So the matter may be listed next Monday. If they are not filing any affidavit, then we can dispose it off.
What is the matter regarding?
The matter is regarding the the present petition is directed against the order dated 8/12/2023, passed by the Lanet District Judge, my lord. In the RFA number 7 of 2022, my lord, the senior civil judge has entertained the application filed by the respondent number 5 under section 151 of the CPC. without knowing, without realizing that the civil court does not have any jurisdiction for allotment of land as per the Revenue Act, the Mizoram Revenue Act, my lord. So the application under section 151 of the CPC filed by the respondent number 5 was entertained and allowed for transfer of the location from Zone 1 to Sakortuichun to Zone 1 village, my lord. And in the meantime, the present petitioner did not have any knowledge of it. And since he was not a party to the present case, he was not having any knowledge of the said application. So, my lord, this impugn order passed by the senior civil judge as well as the district judge is not set aside. I mean, the present revision petition is to be heard, I think.
What has the senior civil judge passed the order? What kind of order was passed?
The order passed by, my lord, it is found at page 1 to 4 is the order passed by the district judge, and page 4 II is the impugn order passed by the learned senior civil judge, my lord. This is an application under section 151 of CPC 1908 for transfer of land of the plaintiff LSC number so-and-so, which is located at Punchong, to the vacant land found by the plaintiff at New Capital Complex Road, Zone 1, Aizol, my lord. And this application was allowed by the senior civil judge. My lord, the case originated...
Civil suit?
Civil suit was filed by respondent number 5 because his LSC was overlapping the LSC of the pro forma respondent herein, my lord.
Who is the pro forma respondent here?
Pro forma respondent is the Rinmoy, or Rinmoy, Srimati Rinmoy.
How many respondents are Rinmoy?
There are 6 respondents, but Srimati Rinmoy is the pro forma respondent. She has nothing to do with the present case, my lord.
R5 has filed civil suit because her land was overlapped by the land of R6.
My lord.
Correct?
Yes, my lord.
And during
the land of R5 was overlapping the land of R6.
5 was overlapping 6?
Yes, my lord. And that is why the Revenue Department issued notice upon the respondent number 5 saying that show cause notice is given and he is to give a reply. And during the, after that, he filed the present civil suit.
Civil suit. And during the pendency of the civil suit,
this application under section 151 was filed by him, by respondent number 5.
During the pendency of the civil suit,
yes, my lord,
the plaintiff discovered that there was another vacant plot of land.
Yes, my lord.
So he wanted that my land should be transferred there.
Yes, my lord.
So he filed 151 application.
Yes, my lord.
So that is how the application was allowed.
Yes, my lord.
Directing the respondent numbers 1, defendant number 1 to 4 to transfer his land to that place.
My lord.
Then after that, what happened? Appeal.
And yes, appeal was filed by
whom?
By the present petitioner. Present petitioner is not party to the said civil suit. He has nothing to do with the civil suit number 77 of 2015, my lord.
Then why did you file?
He filed because in the year 2021, he filed application for allotment of land of the disputed land, the present disputed land at Zone 1, my lord. And the same is still pending before the Revenue Department.
Disputed land means dispute between the...
There is no dispute as such. He applied for allotment of land of the said land.
Where the plaintiff is seeking transfer.
Yes, my lord.
There is one place which according to the plaintiff is empty,
Yes, my lord.
vacant.
Vacant.
So he said, please transfer my LSC to this place.
Yes, my lord.
Then court directed.
Court directed.
But then you say that this land was already discovered by me
I
long time
applied
back,
already.
and you applied for that.
Yes, my lord. My application, everything is there, available on the record.
And so, what did the learned district judge say?
To give liberty to the present petitioner
To file a separate suit?
File a separate suit, my lord.
Okay. Separate suit.
That will not solve the problem, my lord. Here, all my documents, I mean, the application along with the connected documents submitted by me to the Revenue Department is annexed along with the present revision petition.
But
my lord.
who is that plot of land which the plaintiff has found to be vacant has not been allotted to anybody?
No, not yet.
Neither to you nor to him?
Not to him.
It is a vacant plot?
Yes, my lord. It's still vacant. In fact, they can apply for the said plot of land as per provision. I mean, by filling up the application form for the same. However, my application already pending before the Revenue Department. In order to show that, I have annexed a copy of my application. In fact, surveyor was detailed by the Revenue Department and conduct spot verification and submitted a report to the Revenue Department. Before issuing the valid pass to us, to me, the said order, civil court order, was received by the revenue authorities. So until and unless the same is set aside, we cannot do anything. And my contention to lordship is the allotment of land, civil court does not have any jurisdiction as per section 16 of the Revenue Act, my lord. And apart from that, there is no relief as such prayed by him in the civil court, I mean civil case, submitted by him.
Have you annexed that plaint?
Yes, my lord. Yes, my lord.
Civil suit is filed by whom?
By respondent number 5.
Okay.
Against the order passed by the respondent number 3. Respondent number 3 is Director of Land Revenue. He was afraid of cancelling his LSC, since the same was found to be overlapping the land of the respondent number 6. Page number 39, Annex 2 is the copy of
application under 151.
Civil suit number 77 of 2018, my lord.
But is this the original suit?
Original suit, my lord. Right.
No, how can it be? It is an application under 151 only.
No, during the pending of this civil suit number 77, that application under section 151 was filed by the plaintiff.
No, that's why I want to see where is the original civil suit.
Civil suit original is this one, my lord. Civil suit number 77 of 2018.
No, where is the copy of the plaint?
Copy of the plaint is also here, my lord.
Where is that?
Page 39 onwards. Page
But
39.
no, if you come to page 40.
Yes, my lord.
This is an application under 151.
Oh, yes, yes.
This came later on. Before
No,
this,
no, my lord, no.
Before this, something must have been filed. Civil suit.
22. It is there, my lord. I just confused. At page 22, my lord.
22, correct.
Yes,
22.
Page 22 onwards.
Since you said that it's not even his prayer in the suit.
Yes, we can see the prayer.
That's why I just wanted to see.
Page 35, para 26. Number 1, for a degree in favor of the plaintiff and against the defendants. Number 2, for a degree declaring that the plaintiff is the rightful owner over the land covered by so-and-so, which is situated at Sakurtichun. Number 3, for a degree declaring that the LSC number so-and-so belonging to the defendant number 5 is null and void
and is liable to be cancelled. 4, for a degree declaring that the action of the part of the defendant number 1 to 4 in issuing LSC number so-and-so to the defendant number 5 and their actions in entertaining and considering the defunct house pass number so-and-so for making out the said LSC so-and-so is illegal and void ab initio, and to further declare that such illegal actions and any other order passed in this respect by defendant number 1 to 4 as null and void, and for setting aside and quashing such action. Number 5, for setting aside and quashing the impugned order so-and-so passed by the defendant number 3, and also the impugned verification report so-and-so made by the surveyor, Revenue and Settlement Department in respect of the dispute between the land of the plaintiff and the defendant number 5. Number 6, for permanent and perpetual injunction against the defendants, thereby restraining them from disturbing, interfering, issuing, and passing detrimental order against the plaintiff's land covered by LSC number so-and-so, and also from doing anything to detrimentally affect the interests of the plaintiff pertaining to his aforesaid land.
Okay. So Mr. Tlamona wants some time. Mr. Bilra Menga is there for the respondent number 5.
He has already filed affidavit, my lord, respondent number 5.
5 is the beneficiary, isn't it?
My lord. The battle is between me and him, in fact. So if Your Lordship allows us, we can take up the matter by Monday.
What about the pro forma respondent?
Pro forma respondent, she has nothing to do with the present case.
Okay.
Because her LSC is unsafe.
But she is a party, any notice has gone to her?
In fact, my lord, she has already been deleted.
Deleted?
Your pro forma respondent, it is not found necessary to give notice upon the respondent number 5.
She will be so happy if the location is transferred. For former respondent. She will be so happy if the location is transferred.
Because that civil suit also become infructuous.
Yes.
Now, what kind of instruction can you get otherwise?
On whether they are to file the affidavit or not, at least he can find it out.
Yes, my lord. With regard, I have produced the case, I have studied the case, my lord. In fact, however, my lord, to be again on the safer side, I might be given some more time, and this matter may be come up on Monday, my lord. So I think we can.
Okay, Monday.
Monday, my lord.
Parties are represented by the respective councils, except for pro forma respondent number 6. Mr. Benjamin Lal Tlamona, learned government advocate, appearing for respondent numbers 1 to 4. Prays for a week's time to obtain instructions in the matter. In view of above, and as straightforward is the matter again on 24th of March 2025.
Obliged.
In the admission column. Yes.
Obliged.
We'll assemble at 2.
I'm for the state, my lord.
Who are respondent numbers?
2 to 4.
2, 3, 4.
2, 3, 4, my lord.
You have been pleaded as pro forma respondent. So, thing is that whether you have anything substantial to say in this matter.
Regarding that, my lord, since the documents are supplied to the instant petitioner to this RTI, this is from the Revenue Department, my lord. So I might need some clarification with regard to that from the concerned department, my lord.
And if I may make one submission, my lord. I have already mentioned to your lordship in the morning, my lord, regarding that Supreme Court judgment. I mean, I'll just give your lordship a brief facts of what this IA is, my lord. Now, I'll give your lordship brief facts of the case, my lord. 1994-95, my lord, in Zone 1, there's an area called Beramputlang. Now, in this area, my lord, poor people, there were many poor people around Luangmol and other areas, my lord, who did not have houses. So this area was given to poor people by the Zone 1 Village Council. And in this respect, they were allotted certain VC passes, my lord. And the appellant, who is the opposite party today, my lord, and the appellant, the respondent, that is the applicant in this IA, my lord, they were also one of these poor people.
You are the respondent in this?
I am the respondent in the origin. So we were also one of these poor people, my lord. Now we were both allotted land sometime in 1994-95, VC passes. Now, what the VC passes, after VC passes were allotted, my lord, we did not immediately build houses. In 1999, the opposite party, my lord, with the help of the YMA, because he was.
Just a minute. When was it the allotment made? VC
94 and 95, my lord.
94, 95.
Yes.
And again, things started happening 99.
99, construction happened with respect to the appellant's land, the opposite party's land, with the help of the YMA, because he was.
How are you affected?
I'll explain, my lord. I'll explain. Now, thereafter, what happened was 2002, I also constructed land in the plot that was given to me. We are both neighbors, my lord. We lived there peacefully. Now, 2003, my lord, in my absence, there was house passes were issued to different people. Now, when house passes...
Over the plot?
Over the plots we were given. Over the VC passes, house passes were issued, my lord. In fact, all of the Beramputlang, my lord, now areas are LSCs. So house passes were issued. Now, when house passes were being issued to all of these people, my lord, that time my clients were not present. The opposite party, what they did was, my lord, he pointed at both the plots of land, village councils, both the village councils. Even though my house was situated there, he pointed at these two lands. And then he applied for a house pass over both these lands, my lord. And after house passes were issued, my lord...
His land plus your land?
My land. And I continued living there, my lord. There was no dispute. I did not know. In fact, he also did not tell me. And 2006, LSC was issued to him. When LSC was issued to him, my lord, then I found out, my lord, that he had applied for the entirety of the land. So then I made a complaint before the Land Revenue and Settlement Department. And Land Revenue and Settlement Department, they started taking steps since 2008, my lord. And in fact, when they made the demarcations, my lord, they made redemarcations of both the lands. And in that respect, the Revenue Department, they came up with a solution whereby he was asked to gift the portion I was allotted by the village council, gift it back to me. So he submitted a document, a gift deed, transferring me back that land which was allotted to me by the village council. He also signed a no objection certificate. In fact, the Revenue Department, they came up with, they have done all the process. And when they were doing all this process, my lord, finally what the Revenue Department did was, my lord, they said, since the land that was allotted to him is larger than the land allotted to me, he will have to pay for the demarcation fee. He did not pay for the demarcation fee, my lord. And so the matter rested in the Revenue Department because he did not pay for the fee, the final fee. And in the meantime, what he did was, in 2014, he filed an eviction suit before the civil judge. Now, in the civil judge, before the civil court, my lord, he did not mention any of these things which happened in the Revenue Department. He remained silent. But in spite of this, the court passed an order dismissing his suit. and he came up to this court on appeal. And during the pendency of the appeal, my lord, we have found out these documents from our client. Our client is an illiterate person, my lord, and he has not even filed a proper written statement. His written statement is written in Mizo. So now what we have done is, to the best of our effort, we have submitted these additional documents, my lord. And as per this Supreme Court judgment, my lord, when additional documents are filed under Section Order 41, Rule 27, such documents have to be considered at the time of final hearing. My lordship will kindly turn to page number 171, paragraph number 49. Paragraph number 49 and paragraph number 52 are relevant, my lord. I'll read paragraph 49 first. An application under Order 41, Rule 27 CPC is to be considered at the time of hearing of appeal on merits, so as to find out whether the documents and or the evidence sought to be adduced have any relevance bearing on the issues involved. The admissibility of additional evidence does not depend upon the relevancy of the issue on hand or on the fact whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. The true test, therefore, is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. Such occasion would arise only if, on examining the evidence as it stands, the court comes to the conclusion that some inherent lacuna or defect becomes apparent to the court. Now, paragraph number 52, my lord. Thus, from the above, it is crystal clear that an application for taking additional evidence on record at an appellate stage, even if filed during the pendency of the appeal, is to be heard at the time of the final hearing of the appeal, at a stage when, after appreciating the evidence on record, the court reaches the conclusion that additional evidence was required to be taken on record in order to pronounce the judgment or for any other substantial cause. In case the application for taking additional evidence on record has been considered and allowed prior to the hearing of the appeal, the order being a product of total and complete non-application of mind as to whether such evidence is required to be taken on record to pronounce the judgment or not, remains inconsequential, inexecutable, and is liable to be ignored. So, my lord, because of this reason, my humble submission is, my lord, at this stage, let's take up this matter next week or after a week, my lord, for final hearing. Then we can consider this application together with the connected RFA.
This will have to be read from paragraph 36.
Yes. Paragraph
because this kind of discretion lies with the appellate court, no doubt.
Yes.
But it has to be considered.
And my lord, paragraph 49 on top, it's written stage of consideration. So,
yes, it says it has to be produced allowed to be produced in exceptional circumstance. And judicial, it has to be exercised judicially with circumspection, and when court finds that to pronounce the judgment, there is some lacuna, and that is required to be considered.
Yes.
So we'll see. But at any rate, there's no argument regarding that this matter be taken up at the time of hearing.
My Lord, regarding that issue, Lord, if I may kindly be allowed, my Lord, to submit. Regarding that, my Lord, now, my learned friend has invoked Order 41, Rule 27, Lord.
Yes.
Under there, my Lord, there are three distinct conditions under which the additional evidence documents may be adduced, allowed to be adduced, Lord.
Yes.
Number 25, Rule 27A, my Lord. Number 1, the court from where the degree appeal is preferred has refused to admit, number 1. If they go before the trial court at the time of trial and they made an attempt.
That is not the case here.
My Lord.
They have discovered it later on.
Yes, Your Lordship. And AA, the party seeking to produce additional evidence establishes that notwithstanding exercise of due diligence, such evidence was not within his knowledge or could not, after exercise of due diligence, be produced by him at the time of trial. Regarding the, my Lord, if I may take Lordship
something like review.
Their own petition, my Lord. Their own petition, my Lord. If I may take Lordship to the IA, page number 10, my Lord. They allege that this document was obtained by them through RTI, my Lord. And from the RTI supply of document, my Lord, we can clearly see that it's been supplied to them way back on 17th of June 2016, my Lord. At the time when the present case was at the stage of trial, my Lord. But still, they did not produce it. They did not make any attempt to produce it at the trial, my Lord. And now, after 8 years, Your Lordship, they produced it before Your Lordship.
When was the judgment passed?
Judgment was passed in June 2019, Lordship. 19. And now, after that, my Lord, on appeal, we come before Your Lordship. And from the time of judgment till now, my Lord, more than 5 years have passed already, my Lord. And then they produce it only today, my Lord. So they, not only at the time when we preferred appeal, they did not even make attempt to produce this before the Lordship, my Lord. Actually, they are not actually interested, my Lord. So much delay, my Lord. Number 1. Number 2, Your Lordship. They stated that they rely mainly on the allotment of lands to them by the local council, village council at that time, my Lord. That was in 94, my Lord. If I may take a Lordship to my written objection, Your Lordship, by way of affidavit, I enclose one document issued by the erstwhile executive department of the Mizo District Council, Lordship. That was issued in 23rd December 1971, Lordship.
Yes.
This says, Lordship, under Section 3, Subsection 1 of the Lusai Hills District House Site Act 1953, as amended, the Executive Committee of the Mizo District Council is pleased to declare that all lands within the jurisdiction of the village councils of Luang Mual, Tansil, Sakor Tuichun shall henceforth be protected area within the meaning of the said act. No allotment of land for residents, trade, agricultural lands, or other purpose within the said area shall be made by the village council without previous sanction of the Executive Committee of the Mizo District Council. So, Your Lordship, from 1971 onwards, Your Lordship, the concerned village council authority did not have any authority, my Lord, any power to allot land, either for agricultural purpose or for residential also. So their main basis on which they claim the present title over the sued land all has no leg to stand, my Lord.
No, the second part, that is not there. That is there, this last line, this order shall not bar the village council from
Zoom land.
distributing ordinary Zoom lands for a year.
Yes, Zoom land.
So this is for agriculture purpose. They want to grow something.
That
okay.
temporary, my Lord.
This is for 1 year only.
Yes, temporary. Within 1 year, temporary. Also.
See, anyway, we'll hear the parties. Now, since Mr. Benjamin wants some time to get instructions, let him have it. We take it up again after a week.
Yes.
Lordship, yes, 1 week.
1 week, yeah. Maybe next Tuesday.
My lord.
Get your instructions, whatever you have to. Now, how many respondents are here?
Only, my lord, there are 4 respondents.
Okay. Please write down. Parties are represented by the respective councils. And they submit. No. And they submit not required. Parties are represented by the respective council. Full stop. At the outset, Mr. Benjamin Lathamwana, learned government advocate, appearing for the respondent numbers 2, 3, and 4, submits that although the said respondents are pro forma respondents, but he prays that he may be given a week's time to obtain instructions in the matter, since the documents being relied upon in the IA are documents issued by the state respondents. Next para, Mr. Joseph L. Rentley, learned counsel for the applicant, by producing the Apex Court decision rendered in Union of India versus Ibrahim Uddin and another, reported in 2012, 8 SCC 148, submits that an application made under Order 41, Rule 27, CPC, like the present application, has to be heard, has to be considered at the time of hearing of the appeal. Stop. He therefore submits that the entire matter may be taken up for hearing. On a convenient date. Stop. Considering the submissions made. Next para. 1 week is enough? List this matter.
My lord, 2 weeks maybe. It's already Tuesday, my lord. So, 2 weeks time maybe.
I, Your Lordship, also have one citation, Your Lordship, which may not. I'll place it at time of hearing, my lord.
You do that, yes. We're not taking them. I just had made a mention so that we don't forget about this. List the matter. 1st April.
My lord.
Again on 1st April 2025.
Obliged, Your Lordship.
Hearing list, item number 10.
What is this matter? RFA?
RFA, my lord.
You are the appellant.
I am the appellant.
And you are the?
I'm for the respondent, Lordship.
Sole respondent?
Sole respondents.
It's between 2 private parties?
Yes, Lordship.
Okay. You all are ready?
We are ready, my lord.
Okay. Both of you may go.
My lord, I'll try to present the facts of the case very briefly, my lord.
Somebody had mentioned this matter the other day.
Yes, this was the matter we mentioned, my lord.
You had mentioned it.
Yes, for today.
Yes.
So now, my lord, what we are claiming, we are basically claiming that we are both wives of one person by the name Thang Hinglova, my lord. Thang Hinglova was an employee of the agriculture department in Mizoram. And so we are both claiming that we are the wives of, we are claiming that we are wives of Thang Hinglova and that we are entitled to the pension, my lord. I am claiming that I'm the sole wife and she's claiming she's the sole wife, my lord. So that's basically what this case is about. So two people claiming to be the wife of one person by the name Thang Hinglova. Now, my lord, what has happened was Thang Hinglova and the appellant, Zodin Pui, my lord, they got married sometime in 1982, that time. Now, in 1985, my lord, they gave birth, they have 4 children. One was born in 1985, 96, 95, and 96. Now, sometime in 2009, my lord, they separated. Separated means, according to us, there was no divorce. It was just a separation, living separately. Now, in 2009, in fact, the appellant, she had filed an application under Section 125 criminal CRPC, my lord, claiming for maintenance. And the judgment and order in that case was passed on 4/3/2011. I had filed. And maintenance was awarded was given to me and my children, one of my children. In fact, the deceased person, my lord, he did not file any appeal against that criminal complaint and he continued to maintain me. Now, in 2011, as it appears, my lord, he started cohabiting, he started living together with the respondent. And after a point, my lord, from the document that they had submitted, one of the exhibits, it shows that they were, in fact, we are saying that that marriage did not happen, but their basic claim is that he got married to her. This was sometime in 2011. And they lived together till 2014, my lord. Now, after 2014, my lord, what happened was in 2016, he filed a fresh nomination, the deceased person. He filed several nominations for his service benefits. One of them is GIS. And specifically in the GIS, in the nomination letter, my lord, this is exhibit D12. He had named the the appellant as his wife. He had specifically mentioned that she is his wife. Now,
fresh nomination was in respect of GIS?
GIS.
Only?
No, he had filed several nominations, but in the case record, there is only GIS, my lord. We have only the GIS in the case record, D12, exhibit D12. The rest of them were subject of another litigation in WPC, my lord, in another writ petition, because his children were beneficiaries in the other benefits. So they had filed one writ petition against the respondent, and relief was given to them.
What kind of relief?
Some of them, my lord, leave, GPF, those kind of things, my lord. The other service benefits, apart from family pension.
The children from the first wife?
Correct.
And what about the share of the second wife in those writ petitions? Nothing?
Nothing. She was not given because she was not nominated.
So court said that you go by nomination.
We go by nomination.
Then whoever was nominated were the children from the first wife, they should get it.
Correct.
All the service benefits except pension?
Except family pension, my lord. It was equally distributed by amongst the children. Now, thereafter, my lord, the respondent submitted a legal notice to the department claiming for family pension. The subject matter of this case, my lord.
When did he die?
He died in 2016. 26/10/2016, my lord.
What was his position?
His position, my lord, that I'm not sure, my lord, but he works as a AAI. Now, AAI, my lord, is, I'm not sure what AAI is, my lord. Assistant Agriculture, I think.
Inspector.
Yes. So he was posted at Lunglei first. This was where the respondent used to live. The respondent lives at Lunglei. So he met her at Lunglei. I think that's what happened. And then after that, he got transferred to Longklai. So when he died, he was posted at Longklai, my lord. Now, she filed a legal notice. And then after the legal notice was filed, the department processed the pension in my favor in spite of the legal notice. And thereafter, she filed a heirship certificate case. Now, the heirship certificate case was given to her, then we filed an RFA. The RFA, after we filed an RFA, that heirship certificate got set aside, my lord, and it got remanded back to the lower court at Lunglei. And then there was trial. And after trial, it was decreed in her favor, and so that's why we have come before this court, my lord, by way of RFA. Now yes.
Okay. So what happened before the heirship court? What sort of evidence was taken?
Yes, my lord. So what we have produced, my lord, we had produced my lord, we had produced three witnesses, 3 oral witnesses, and 12 exhibits. And they had also produced 5 witnesses, and they had produced 11 documentary evidences. Now, our basic argument, my lord, is firstly that me and the deceased person, my lord, we definitely got married. There is presumption of marriage in our favor, and that presumption is strengthened first by that criminal complaint order, my lord, and second by that form number 7 in the nomination letter where he named me as his wife. And also there is one letter dated 28/4/2016, 28/4/2016, my lord, in which he had specifically mentioned that the respondent is not his wife. And also he made a will dated 3/5/2016. I'll take your lordship, my lord. Let me first take your lordship to exhibit D12. It's part of the record.
You'll refer to the paper book?
It's in the loose sheet, my lord. Initially it was not given to us. So it was subsequently provided to us. It was not part of the legal, paper book.
It's not a part of the paper book?
No. Because this was filed separately in the lower court. This was exhibit D12. Application.
This is an original?
Application under CMA number 70 of 2019, my lord.
Exhibit D?
12. The annexure there, my lord, is exhibit D12.
Yes. Form
Yes.
7.
Yes, my lord.
That's what you're referring to. Yes.
Yes. My lord, in this form number 7, yes, exhibit D12, if your lordship will see, the name of their children are mentioned at 1, 2, 3, 4. And on the right side, my lord, you will see number 6, serial number 6, Zodin Pui.
Who is this?
This is the appellant.
Appellant.
Now, this document was not considered by the lower court, my lord.
Then how many children here?
4 children.
What's the name? Zodin Pui.
Zodin Pui, my lord, that is the appellant.
But where's the nomination?
The nominees, my lord, the nominees are Lal Thanpuya, Lal Faxwala, Emily Lal Rinpui, and Lal Ramruata. So they are supposed to share. They are supposed to share this in equal proportion, my lord.
This is nomination in respect of
The state government employee group insurance scheme.
GIS.
Yes, GIS. And in the event.
What about the share of the wife?
So the wife is, my lord, it's written contingencies on the happening of which the nomination shall become invalid. Death. Now name, address and relationship of the person, if any of whom the right of the nominee shall pass in the event of the predeceasing the government servant, Zodin Pui, wife.
It means that if all these children predecease
Yes.
the government servant,
Yes.
the nomination will go with the name of the wife.
With wife. The reason we are
Otherwise, if they are still around, then they will go to the children only.
correct, my lord. And the reason we are producing this, my lord, is
To show
because
that there's wife.
yes,
This was exhibited.
this was exhibited, Exhibit D12, my lord. Your lordship will see DW in our paper book also. If your lordship will come to page number 32. Page number 32 of the paper book. (132) of the paper book, Exhibit D12. Yes. Exhibit D11 is that CMA application we had submitted. So that is one, my lord. Now, before he died, my lord, he had also executed a will at page number 65 of the paper book. Page number 65. This was Exhibit D9. Now in this, my lord, he had specifically mentioned 100% of my pension will be the share of my wife, Zodin Pui. Wife, Zodin Pui. And this was probated, my lord. Page number 66. Yes. This was probated, they had not challenged. It remained final. Exhibited. D10. And If your lordship will come to that criminal complaint, order passed in that criminal complaint, my lord. It's at page number 57. $125 maintenance. Now, this was also given. This was Exhibit D6. Now, maintenance at page number 58, last paragraph. Order. The respondent is hereby ordered to give maintenance allowance of rupees 1,000 per month to the petitioner, rupees 4,000 per month to his minor son, Lalremruata. Lalremruata is the youngest son. Then we made one RTI application, my lord, at page number 54. Yes. 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 Correct, my lord. Yes. Page 54 is the RTI application, my lord. We had filed, wherein we had asked several questions. The first question we asked was, did the said Sri Thang Hinglova make any application for permission to marry the said Srimati Vanalpari in accordance with the proviso to Rule 21 of CCS Conduct Rules? Did he divorce his first wife through a court decree? If he had not divorced his first wife, did he maintain her? If yes, any court order to that effect in your office? All the documents submitted to your department by Srimati Vanalpari. Then a reply was made from page 55 onwards, and in the reply, my lord, this is Exhibit D4. The reply is Exhibit D5. It starts from page 55. Page 55. Page 55, the relevant portion is at page 56. The late Sri Thang Hinglova did not make any application to marry Srimati Vanalpari so far as knowledge of this department is concerned. The department is unaware of his divorce of his first wife through a court of decree. Yes, he maintained her, and copy of court order is enclosed herewith. Documents submitted by Srimati Vanalpari to this department are enclosed herewith. Now, documents enclosed included one legal notice that she had submitted, my lord, and this is at page number 60. That RTI reply was Exhibit D5. And this is the one of the documents they gave to us was the legal notice at page number 60, Exhibit D7. In this, my lord.
Anything to be looked into?
Yes. In this, my lord, if your lordship will come to paragraph number 6.
Yes.
Paragraph number 6, she had specifically stated like this, my lord, in the last part, that my client husband.
This notice is by the
respondent.
The
reason we have used this, my lord, is because in paragraph number 6, it says like this, that my client husband was a habitual drinker without his consent. My client husband's son, Lal Thanpuya, had forcibly taken him at Aizawl, and my client husband died at Aizawl, and the cause of death was not informed to my client. That my client husband had divorced wife. So she accepted that she was the wife and having 3 children from her previous marriage. That my client and her husband Thang Hinglova did not have any children, and the children from the divorced wife had taken my client husband without her consent and without the consent of my client. So now this legal notice was issued after Thang Hinglova died. Now in this legal notice also she admitted that he had a first wife, who is the appellant.
So despite this legal notice, pension was processed in your name?
Initially.
Then thereafter,
she
applied for headship
certificate. Yes.
And was granted.
It was
then you filed an appeal?
Appeal. And that was set aside.
Appeal before which court?
High Court, my lord.
Before the High Court?
Yes.
It was set aside and remanded back?
Yes.
On remand, again, it has been decided in the favor of the respondent?
Correct, my lord.
Okay.
So that is the legal notice, my lord. Now, judgment and order in WPC number 217 of 16 at page 63, my lord, Exhibit D8. Exhibit D8. It says like this, my lord. This was when the children, my lord, had applied for the service benefits. Heard Mr. Joseph, sorry, I'll read from the second paragraph. Matter relates to claim of the retirement benefit like the death cum retirement benefit, DCRG, General Provident Fund, and Group Insurance Scheme, my lord. Group Insurance Scheme, my lord, that form number 7. And one, Thang Hinglova Tlang Nuam, who is the late father of the writ petitioners, who served in the Agriculture Department, Government of Mizoram, and who died in harness on 26/10/2016. Though the petitioners claim for such benefits due to, on instruction, Mr. Samuel Vanal Shriara Changte, learned government advocate, submitted that the respondent number 5 filed a legal notice and also filed application before the District Agriculture Officer, Longklai District, Longklai, on 28/4/2016. My lord, this letter is significant. 28/4/2016 letter, my lord, because I'll explain after this. Claiming to be the wife of deceased Thang Hinglova, and that she has also claimed for such service benefits of late Thang Hinglova, and that the state respondents, considering the legal complications, have not released such service benefits of late Thang Hinglova to the petitioners. Though notice has been duly served on the respondent number 5, and the registry have received back the AD card after such service of notice on the said respondent, but till date the said respondent number 5 has not entered appearance in the matter, and as such the matter is proceeded ex parte against the respondent number 5. As the name of the petitioners have been duly nominated by the deceased in his pension document with regard to the DCRG, GPF, and GIS of the said Thang Hinglova, and that as the respondent number 5 failed to place any legal entitlement for the same, the respondent numbers 1 to 4 shall disburse the said DCRG, GPF, and GIS to the petitioners in 4 equal shares by 31/3/2017, which shall be paid by them by account payee check on their proper identification obtaining receipt. The petitioners shall submit certified copies of this order before the respondent numbers 2, 3, and 4 on or before 24th February 2017. Now, my lord, in this they have mentioned the GIS also, my lord, form number 7, which I had mentioned before. So the court accepted that, and that has not been challenged. And also, my lord, your lordship will see in the first page, your lordship, in the bottom, it says she had filed one letter dated 28/4/2016, claiming to be the wife of deceased Thang Hinglova. Lordship will see that. Now, my lord, on the same day, my lord, at page number 53, my lord will see the writ petition order, yes. Page number 63.
Yes.
My lord, on the bottom, my lord will see before the district, and also filed application, my lord, before the District Agriculture Officer, Longklai District, Longklai, dated 28/4/2016, claiming to be the wife of deceased Thang Hinglova, and that she has also claimed for such service benefits. Now, my lord, on that same day, and this explains why this letter is important, my lord, if your lordship will come to page number 53. The Mizo translation was provided to us subsequently by the court, my lord. Page number 53, this is the English translation. It says like this: I Thang Hinglova, AAI post Longklai, kindly request you not to give hand over my salary to anyone unless it's me or my son Lal Thanpuya who resides at Son Puiveng Aizol. I came to know that Vanal Pari Lunglei Luangmol tried to take my salary. She also took my important document, GP Fund withdrawal application and GP Fund statement from Directorate of Agriculture Aizol without my approval. I beg you not to further give anything to her without my approval. Vanlal Pari and I are not married. She is not my wife, nor does she have any authorization. This was Exhibit D3, my lord.
Okay.
According to us, my lord, any presumption of marriage in her favor, my lord, has been rebutted by the deceased himself through this letter. Now, but my lord, let me also place to your lordship one very important document, my lord, because these documents give an important picture.
Yes, which one?
My lord, this is an order. My lord, let me see the. This is at page number 34, my lord. This is an order that was passed in a criminal complaint that was filed by the respondent. Sorry, by the, yes, respondent. Petitioner is present along with her counsels. As per the order of this court dated 18/2/2014, Thang Hinglova is produced by authority of sinner's friend, Sipir. Even though Phuket Lianthanga, against whom a complaint is made, is summoned, he is represented by his secretary, Tlangwal Jacopa. Besides, son of Thang Hinglova is also present. Parties pray for disposal of the case without taking further examination, as it is of a family matter. I heard the parties at length. On perusal of the examination of complainant and upon hearing parties, it is apparent that the complaint is related to family dispute. Accordingly, the story necessitating this complaint is highlighted from the statement of connected persons. Vanlal Pari, who is the present wife of Thang Hinglova, states that she is the legal wife of Thang Hinglova. She submits attested copy of marriage certificate issued by marriage registrar and Manhlanna in support of her claim. She states that she has no children with Thang Hinglova. However, Thang Hinglova has 3 children with his previous wife. One of his sons, Lathanpuya, forcibly took out Thang Hinglova from gospel camping and admitted to rescue home sinner's friend Sipir. As soon as she came to learn that her husband is admitted to rescue home sinner's friend Sipir, she went to the said home in order to meet her husband. However, the authority of the said home did not allow her to meet or to talk to her husband, Thang Hinglova. Besides, her husband is a government servant presently posted in the office of DAO Lunglei, and leave availed of by her husband is almost expired. Since her husband is of alcoholic, she has lots of debts to various persons. She further states that if her husband is not released, his sons shall obtain authorization from him and draws his salary for them. She therefore comes to this court to help take out her husband. Lal Thanpuya, son of Thang Hinglova, states that since his father is alcoholic, he badly needs treatment at rescue home, particularly rescue home sinner's friend Sipir. If his father is released, he will resume drinking of alcohol and there is risky for his life. Besides, they have no knowledge that the complainant is the legal wife of his father, but at the same time, they have knowledge that his father is to live with the complainant. He therefore prays to dismiss the complaint and not to allow the release of Thang Hinglova from rescue home sinner's friend Sipir for the safety of Thang Hinglova. He further states that he is the person who admits his father to the said home with the consent of his father. Jacob, secretary of sinner's friend, states that Thang Hinglova was brought to their camp by his sons and admitted accordingly with the consent of Thang Hinglova. He also states that though there is a rule in their camp, there is no problem for release of Thang Hinglova if Thang Hinglova wish to go out of the situation compels it. There is heated discussion, so all the persons except Thang Hinglova were sent out of the court. Thang Hinglova states that his physical and mental is fit to use his conscience. He could answer all the questions put to him by this court rationally. He states that he loves both his present wife and his children. However, both hate each other. He is a government servant, almost attaining the age of 60 years. He also states that he was admitted into the said rescue home with his consent. From the statement of Thang Hinglova, this court presumes that the complainant and the children of Thang Hinglova have a problem relating to the salary and the pension benefits which shall occur when Thang Hinglova is released on superannuation pension. Whereas Thang Hinglova is mentally and physically fit to make decision and the rescue home is ready to release him. He is at liberty to decide whether he should remain in the said rescue home or leave the same subject to the rules of rescue home. Besides, he is also at liberty to decide how to spend his monthly salary and pension benefits. Since the Home Authority, Thang Hinglova and his sons revealed that Thang Hinglova was admitted and is remaining at rescue home Sinner's friend, this court is of the view that the Home Authority could not be deemed to have confined Thang Hinglova wrongfully. I therefore do not see sufficient ground to further proceed under section 344 IPC. It is made clear that no one is allowed to deprive the life or personal liberty of Thang Hinglova except according to the procedure established by law. No one is allowed to have caused the consent of Thang Hinglova by coercion, undue influence, fraud, misrepresentation, or mistake. The Home Authority is also directed to release Thang Hinglova if he wishes to go out subject to their rule. Now, this was in 2014, my lord. So now, my lord, looking at all of these things, what appears to have happened, my lord? Thang Hinglova, he's a drunkard, my lord. I mean, he's an alcoholic. And when he got posted at Lunglei, it cannot be denied that he and the respondent, they somehow cohabited, my lord. Now the marriage, whether the marriage itself is a valid marriage or not is a different matter, my lord. But it is clear from this order, because this order of... No, the learned trial court, my lord, the learned trial court relied on certain documents submitted by the respondent.
Which you have not referred to till now?
No, I will take your lordship. Because these documents, they were all issued, my lord, after the appellant left Lunglei. After this order, my lord.
Issued by whom?
One is a voter ID, which was issued in 2015, and according to the respondent, the voter ID was applied by her. The second is a ration card, my lord, which was also submitted, which was also issued. The ration card was issued. In fact, I think the ration card, my lord, was issued in 2016, which was way after he had filed that nomination, my lord. And according to the evidence, she had made the application herself. And then the other one she had submitted, my lord, was an Aadhaar card. The Aadhaar card was issued to her in 2017, my lord. That was after the death of Thang Hinglova. And she had also submitted one the marriage certificate, which she had claimed, and one Manlanna document. And based on that, my lord, she was decreed, she was given the benefit. Now, none of the documents which I have presented to the court, my lord, the letter, the nomination letters, none of these things were considered by the court, my lord.
See, one thing which you just read from this order.
Yes.
He states that he loves both his present wife
yes.
and his children.
Yes.
However, both hate each other.
Both hate each other.
You are nowhere in the picture.
Correct. 2014, my lord, they were still living separately. Cannot deny this fact, my lord. What must have happened? He got married.
They were separated.
Separated.
So he cohabited with the respondent. So what he said here was that his children came and dropped him in that sinner's friend home.
Yes.
Of his own free will.
Because he was drinking too much.
And the wife filed an application saying that he was forcibly taken there.
Correct.
Court said that no, he can decide for himself.
Correct.
So you should release him.
Yes.
And in the meantime, some observation was there wherein what he had stated was recorded.
Yes.
He loved both his present wife, that means the respondent, and the children also.
Children.
The original wife or the first wife was not in the picture.
Not in the picture. So that much we cannot deny, my lord. But what must have happened, my lord? This is how I can understand the case, because first he was married to the first wife. Then during this period of divorce, he got married to the second wife, or he started living with this second wife. Then after this incident, my lord, after this drinking incident, he left the second wife also. and he continued to live with his children and his first wife because of the evidence of the first wife, my lord. In fact, he died in the home of the first wife. And the funeral was also done in the home of the first wife.
Okay.
So there was a time when he lived with the respondent. We cannot deny this fact. But he continued to cohabit with the second wife after this incident. The reason I'm saying this, my lord, is if your lordship will come to page number 132. This is further examination in chief. 1, my lord. After the death of my husband, the department in which my husband had worked, namely Directorate of Agriculture, Aizawl, Mizoram, had paid me an amount of rupees 50,000 as condolence ralna. They also gave me one photo album. Aizawl Klang Nuam Wayame also paid me a sum of money and Holy Bible as condolence ralna, and various departments of Klang Nuam Salvation Corps also paid me several things as condolence ralna. I was also given several things as well as money by several individuals as condolence ralna. When my husband died, I and our children, born in wedlock between me and Thang Hing Loa, prepared the grave of my husband, and we have continued to take care of the grave. All the burial ceremony was conducted in our residence at Klang Nuam. In the death certificate also, the name of the appellant has been written as the wife.
Yes.
So, my lord, what must have happened was there was that brief period when he lived with this woman, but then after that he continued living with his first wife.
You were just referring to page 130?
130, my lord, is the
deposition.
These are the depositions. These are the examination in chief of the appellant. It continues from 120. It starts from 123. Should I read, my lord?
Just a minute. Yes.
From page 123 it starts, my lord.
123?
Yes.
What is this?
This is her deposition, my lord.
Then what is this page 132?
132, my lord. The reason I have taken your lordship to 132 is because I want to show to your lordship that before he died, Thang Hing Loa, he continued living with his first wife, the appellant. Because in further examination in chief,
This is a further examination in chief.
Yes, yes.
Beginning is at page 132,
Correct.
123.
Yes, my lord.
Okay. Yes.
So basically what she stated was that they continued to live together again, my lord. I'll read from 123, my lord. The picture will become clear, even though it's quite long, my lord. My lord, from paragraph number 2. I got married to the deceased Sri Thanghing Lova in accordance with the Mizo customary law Manhlan. We had 3 children in the said wedlock. That my deceased husband worked in the Department of Agriculture, Government of Mizoram, holding different posts. He had served in the said department till he passed away on 26/10/2016. During our marriage, we had innumerable fights and disagreements as my deceased husband had acute alcoholic dependency problems. This addiction problem of my late husband created an unhealthy living environment for me and my children, which left me no choice but to leave him and live separately with my children. However, there was no judicial separation or any form of separation in accordance with the Mizo customary law. I want to mention here that my deceased husband Sri Thanghing Lova continued to provide maintenance to me in accordance with the court order dated 21/3/2011, passed in criminal complaint number 99 of 2009. Before the death of my husband, we began to live together again as husband and wife. The applicant was not even present when my husband was sick or at the time of the funeral of my deceased husband, Sri Thanghing Lova. I was the one who took care of my husband. It is also pertinent to note here that the death certificate of my deceased husband was issued to me. That to my knowledge, the applicant has a husband, and that in the wedlock with her husband, she has some children, and that she has not legally divorced him. I will read that, my lord. She has 2 previous husbands, and they are not divorced. That even before the death of my husband, the applicant had taken undue benefits from the service of my deceased husband by fraud.
Who is this applicant?
Applicant is the respondent, my lord. I was the respondent there in the lower court. I was the...
Okay, applicant in the heirship certificate.
Yes, yes. That even before the death of my husband, the applicant had taken undue benefits from the service of my deceased husband by fraudulently deceiving the state authorities. In fact, this caused my husband to eventually write a letter to District Agriculture Officer, white letter dated 28/4/2016. The content of the said letter is reproduced as follows. This is Exhibit D3. The Mizo version is written there, my lord. Kalausia danin vanal pari lunglei luang mol hian kahlo lola katuma. Ka document poimo GP fund withdrawal online le GP fund statement to Directorate of Agriculture isolator in kaphalna tel lavin alola chuak boka. Khongai takin ka thu lovin in engma lo pe chuak to lo turin ka nge na che vanal pari nen hian in na kan nei lova kan nupui ani lo wa authorization po engma anei lo. Then at page 125, it is clear from the above letter dated 28/4/2016, written by my husband himself, that Sri Vanal Pari is not his wife, as he himself had denied to the same. That furthermore, any claim of marriage by the applicant between her and the deceased husband cannot be accepted considering Rule 21(2) of the CCS Conduct Rules of 1954, restriction regarding marriage. No government servant having a spouse living shall enter into or contract a marriage with any person, provided that the central government may permit a government servant to enter into or contract any such marriage as is referred to in Clause 1 or Clause 2, if it is satisfied that A, such marriage is permissible under the personal law applicable to such government servant and the other party to the marriage, and B, there are other grounds for so doing. The definition of spouse in terms of CCS Conduct Rules 1954 can be gathered from Section 2C1 of CCS Conduct Rules 1954 itself, which is as follows. 2C1. The wife or husband, as the case may be, of the government servant, whether residing with the government servant or not, but does not include a wife or husband, as the case may be, separate from the government servant by a decree or order of a competent court. Since there is no separation of divorce between me and my deceased husband by any decree or order of a competent court, the purported marriage between Sri Vanal Pari cannot be contemplated or accepted in relation to the service of my husband. That an RTA application was made on my behalf by my advocate, White RTA application dated 5/6/2018, asking for the following information. Did the state Sri Thanghing Lova made any application for permission to marry the state Sri Mati Vanal Pari in accordance with the proviso to Rule 21 of CCS Conduct Rules? Did he divorce his first wife through a court decree? If he had not divorced his first wife, did he maintain her? If yes, any court order to that effect in your office? All the documents submitted to your department by Sri Mati Vanal Pari. That a reply to the same was made by letter dated 12 June 2018. The content of the said reply is reproduced below. The late Sri Thanghing Lova did not make any application to marry Sri Mati Vanal Pari so far as knowledge of this department is concerned. The department is unaware of his divorce of his first wife through a court of decree. Yes, he maintained her, and a copy of court order is enclosed herewith. Documents submitted by Sri Mati Vanal Pari to this department are enclosed herewith. That in the application submitted by the applicant has submitted several documents. In this respect, the family ration card submitted by the applicant is also not reliable. On a prima facie examination of the family ration card, the same was issued to the applicant herein based on the application that she had herself made. In this respect, the only conclusion that can be drawn considering the above stated facts is that the application she submitted is fraudulent and the above document was obtained by fraud. Furthermore, on examination of the voter ID submitted by the applicant, it is also prima facie clear that the same was issued to the applicant by the authorities on the application of the applicant herein. The application she submitted to the authorities is clearly fraudulent. The document submitted by the applicant shows that the applicant is a fraudster and the court should not perpetuate illegality by accepting the said documents as evidence. The said illegal documents do not prove that Srimati Vanal Pari is the wife of Sri Thang Hinglova, but the said documents are proof of the fraudulent intention of the applicant. The applicant is liable to be prosecuted in accordance with the relevant provisions of the Indian Penal Code 1860. In any view of the matter, it is repeated that as per Rule 21(2) of the CCS Conduct Rules 1964, a government servant having a spouse living is not permitted to enter or conduct marriage with any other person unless permission is granted by the government. That I beg to reiterate that since the applicant was not the wife of the said deceased,
All
said,
right, all right, Mr.
Yes.
Joseph, I've read it. It is also something in the form of a counterclaim.
Yes. No, this was, yes. This was from the counterclaim itself, my lord.
Huh?
This was from the counterclaim that we had
No,
submitted.
this is the evidence of the witness number 1 for the defendant.
Correct, yes.
So out here, you say that you should dismiss this thing, and
Yes.
on the other hand, to declare that I am the wife of the deceased.
Yes, correct.
For the purpose of pension, leave, salary of my deceased
Yes.
husband. So this is the evidence of the appellant.
Yes.
Who else were there?
Now-
And the further evidence in chief is regarding the condolence, what do you call it? Money given by the YMA and all that, that.
Yes, and also in paragraph 2 of that further examination in chief, my lord, not just the YMA, my lord, Directorate of Agriculture, basically she was acknowledged as the wife by the entire society, my lord. And number 2, my lord, when my husband died, I and our children born in wedlock between me and Thang Hinglo prepared the grave for my husband, and we have continued to take care of the grave. All the burial ceremony was conducted in our residence at Klangno. My lord, I cannot imagine of a situation where people would conduct a burial ceremony if she's not the wife or the family. My lord, it's hard to understand. And the respondent, my lord, she was not even aware of the death of Thang Hinglova in her in chief. That's what
Because they were not living together.
They were not living together.
Later on, he came back.
Yes.
So, anything there in the cross-examination?
Of the wife?
Yeah.
The second, my client, my lord?
Yes.
Yes, my lord, at page 133.
No, anything there to be looked into?
Yes, my lord. One is at paragraph number 5. My lord, there was a mistake in the examination in chief wherein she stated they had 3 children. But my lord, at page number 133, she had clarified.
4.
Yes, because children, she had not mentioned the daughter, my lord. It is the fact that we had 4 children out of the said wedlock with my husband Thang Hinglova, namely Lal Thanpui, Lal Fakzwala, Emily Lal Rempui, and Lal Remrota. So in the cross-examination only...
What about number 5?
Lal Thanpuya, Lal Fakzwala, Emily Lal Rempui, and Lal Remrota. So 4 children, my lord.
What about serial number 5?
Serial number 5, my lord. It is a fact that I have no marriage certificate and we have no Manlanna Lekha. The same were misplaced by my mother. So this is also important. I wanted to place this. The reason is, my lord, she has not submitted the Manlanna documents and the marriage certificate in the court. And I think she has clarified it in the cross-examination itself because she had stated that it was misplaced by her mother.
So, why should she say that we have no marriage certificate? She should say that I have marriage certificate, Manla and everything, but we have misplaced it somewhere.
I mean, that's how it was recorded, my lord. But
otherwise, it gives an impression that
yes,
they were not legally married.
Yes, yes. But my lord, the second part clarifies it. Misplaced by my mother, my lord. I mean, the intention is clear. My lord, that's how it was recorded. But
see,
otherwise...
the problem is that, you see, generally, in the district courts, we try to record everything in English.
Yes.
And the person who comes and appears before the court
yes,
as a witness is not necessarily fluent in English.
Yes.
He or she will speak in vernacular.
Yes.
Somebody will translate and just write down.
Yes. That's true.
So, some translation are done in such a manner that, there's no nexus with what the person is trying to say.
Yes.
So it is done in that manner.
Yes.
So one has to be careful.
Yes.
Of course, English is not our mother tongue, no doubt. But to project something which was not said,
Yes.
there are every chances of things happening, because one gets the feel of that.
Yes.
When you go through the depositions, any case, not this
Yes,
case,
yes, yes.
any other case,
Yes.
generally, they make all attempts to write the thing in English.
Yes.
Especially in POCSO case also.
Yes, yes.
The crucial points are, not there.
Yes.
Somebody has translated in such a manner that it creates some doubt.
Yes.
And once that doubt happens,
Yes.
naturally in criminal law, it goes in favor of the other side.
Correct,
For the accused.
My lord, if that second sentence was not there, it would have been completely different. The same were misplaced by mother. I think that clarifies it. What she is trying to say is, my lord, I have not been able to produce them in court. That's basically what she's trying to say. I don't have the documents today. The same were misplaced by my mother. Otherwise, the question of misplacing does not exist, my lord.
I think that's it. And other points are anything? Any relevant points in this cross-examination?
No, in this cross-examination, no, nothing as such.
Okay, now number 2.
Now, number 2, my lord, is DW number 2 is at page number 134. Very short in chief, my lord.
Who is he? She?
This is a he. This is a he, my lord. So what he had done was
Witness number 2 in the heirship certificate.
DW number 2, page 134. He says like this, that I was a witness to the marriage of Sri Matizaudin Pui and the deceased Sri Thanhinglava, who got married in accordance with the Mizo customary law Manlan in the year 1984. Now, my lord, many of them are not clear about the year, my lord. Some of them are mentioning but this year he has mentioned 1984. In fact, I was the person who had handed over the bride price man to the defendant family. Since the defendant's father had died by the time of the marriage, the bride price was handed over to the mother of the defendant. That the statements made at paragraphs number 1 and 2 of those stated in this paragraph are true and correct to the best of my knowledge. Now, in the cross-examination at page 136.
So marriage was in 1984?
Yes, because the problem with their marriage, my lord, initially they eloped. So initially they eloped, and after the elopement, my lord, after a point, that formalizing was done, that paying of bride price and all of those things.
When did they elope? Before 1984?
The elope, I think, my lord, has been made 1983, like that, my lord. It's not clear. The years have not been provided when they eloped. But at page 139, the last witness, my lord, he has mentioned all of these things in his cross-examination.
Okay, what is the cross-examination of this DW2?
Cross-examination at 136. It is a fact that I do not know whether the plaintiff Vanal Pari and the deceased Thanhinglova were married or not. It is a fact that we have paid the price of bride Zaudin Pui to her mother at Venglai Lunglei, but I forget the date and month. But at the time, there is no any other person who were man Eitute. It is a fact that I do not know Thanhinglova and Zaudin Pui had solemnized their marriage before the pastor or church elder. It is a fact that we have paid 400 rupees and 20 rupees as price of bride. It is a fact that I do not have any document proof of the said Manhanna before this court. It is not a fact that I had falsely deposed my statement in this court today. Now finally, the last witness, DW6.
DW6?
Sorry, DW3 at page number 137.
One is the appellant herself, 2
Yes.
is the person who had given the bride's price.
Yes.
3 is, who is 3?
3 is when they had separated, Zaudin Pui tried to return the bride price, but they did not go through with the divorce. At paragraph number 4, my lord, 138, he says like
the
this.
elder brother of the deceased.
Yes. Elder brother means, my lord, they are cousins, not...
Okay.
So paragraph number 4 says like this. That I was present when the defendant Srimati Zaudin Pui came to return the bride price as per the Mizo customary law. But we refused to receive the bride price, and the dissolution of the marriage as per the Mizo customary law was not completed. and both the parties remain separated without any proper judicial separation or any form of separation in accordance with the Mizo customary law. In other words, they continue to remain a married couple. In fact, before the death of Sri Thanghinglova, the two of them lived together again until the death of the said deceased Thanghinglova. Then his cross-examination, my lord, at
So he's talking about Sumchua.
Sumchua. So the first one, the person who received the bride price. The second is, he's saying we did not want to take the Sumchua. Receive it. So they did not get divorced. And in fact, they started living together again before he died.
How do you say he's the cousin brother?
No,
Because he simply says that I'm the brother.
No,
I'm
1
the
minute,
elder
my
brother.
lord. I think I could have mistaken also, my lord. Let me just see at page number 139. I thought I
No,
read it somewhere.
Just look at the father's name, Saptona. He's the son of Saptona. Who is the father of the deceased?
Father of deceased. Tang Qi. At
So-
page number 33, my lord. So he's not, they're not blood, they're not real brothers.
Oh.
So 139.
Tang Qi. Saptona. Okay, different person.
Yes.
Okay.
So 139 is his cross-examination. Here,
But then again, this is a examination in chief by way of an affidavit.
correct.
It is not that somebody has deposed and somebody is writing down.
Yes.
Prepared in the chamber somewhere.
Yes, yes, yes.
And he says elder brother. So could it be a step brother or something?
No, so, my lord, at the time of preparing, now in Mizo, my lord, many times people, they randomly say, he's my brother. So when he said, he's my brother, my lord, it was, in fact, it was prepared by us, my lord. We did not think so carefully. So we had typed it, everything. When we were in Lunglei, my lord, then he said, I think this is how I remember. When we went to Lunglei, he said that he is not the real blood-related brother, but he is just like the brother, like as close as any brother, like that. I mean, they live together and they have that kind of bonding, like brother relationship. But they're not like same father, same mother, like that. But they are relatives. My lord knows this happens all the time, my lord. Like people will say, he's my brother and all. So that's what happened. But anyway, my lord, he knew them very well. They are very close family, and he was there when they were going to return the bride price, and he did not want to take the bride price.
So where was the bride price supposed to be returned when this DW3 was present? So it seems they are quite closely knitted.
Yes.
Witnessing the marriage, Manlana, okay, fine. But then again, witnessing or being present when the bride's price was supposed to be returned.
It seems, my lord, even the appellant and Thang Hinglova, the deceased person, my lord, they are actually blood related. In fact, the reason why the marriage could not be regularized in the beginning was because the family objected. Both
family of the appellant and the deceased were
family
related.
They are related.
To each other.
Related. They are close family.
Okay. How do you say that?
They said they are blood related.
Huh?
That they say they are blood related, my lord. That's all they said.
No. Question is not your knowledge. Is it in evidence anywhere?
She has stated, my lord.
Who? The appellant?
Yes, my lord.
Where?
1 minute, my lord. My lord, in her cross-examination at page 133, at paragraph number 9, it is a fact that we have family blood relation with my husband.
Okay.
And this person, my lord, that I had just read out,
Which person?
page number 138, and his cross-examination is at page 139.
See, I'll inform both sides. I don't think it's possible to complete this matter today.
Yes, Your Lordship.
And I would like to rise early also.
Yes.
Another 5-10 minutes, I'll rise.
All right.
I've got some other issues. Okay?
Okay, problem.
And we may perhaps continue this tomorrow being Wednesday. Perhaps we'll be having DB. Maybe we can have it on Thursday.
Yes.
All right, Your Lordship.
Okay, keep
Yes,
that
yes.
in mind.
Yes.
Yes.
My Lord, at page 139.
139,
Yes. At paragraph number 8.
para 8.
Yes. So this was the person who had paid the bride price, my Lord. Sorry, who was refusing to accept the return of the bride price. Paragraph number 8. It is a fact that the deceased Thanhinglova and the defendant Zodinpui were blood relation. Due to this, the family did not accept marriage between them before giving the said bride price. They were married secretly, and after we came to know of their relationship, we paid the bride price. So,
Again, he says 3 children.
no, he says it is a fact that I remember till the third child was born between them. But later on, I do not have much knowledge about their exact condition of living. So they also do not have complete knowledge of their family also, my Lord. It's possible, my Lord, one living in Lungle, the other living in Aizawl.
So marriage solemnization was not there, but that Manhlanna was there.
Yes, Manhlanna was there. He's saying that in my knowledge, in his knowledge, they have no solemnization. That's his knowledge.
But the person who had himself paid the bride price has deposed, isn't it?
First one, my Lord.
DW2.
Yes, yes. At page number 136, he had deposed that they had paid the bride price. Even the person who paid the bride price is saying they don't know whether they had solemnized the marriage.
Okay. Any other witness?
So there are only 3 witnesses, my Lord.
One is the appellant herself. Second one is the so-called brother, relative.
Yes.
And the third person?
Is the guy who had paid the bride price.
Number 2, who's number 2?
Lordship, number 2 is the person who had paid the bride price. And number 3 is the
Yes.
person, the brother who was not willing to accept the bride price.
Okay. 2 had paid the bride price,
Yes.
3 did not want to receive it.
Yes,
So altogether 3.
correct.
See, what remains today, as on today? Just the family pension and the GIS.
GIS is done, my Lord. GIS was
Who has got it?
in the writ petition, my Lord. The writ
Oh, it
petition.
was a part of the writ petition. Okay.
Yes. The High Court accepted that,
Only the family pension.
only the family pension.
The official respondents could not decide what to do, or what, because
Because
of
of
the
the
pendency.
heirship.
Because of the heirship.
Yes. Our submission, my Lord, I'll just give your Lordship the crux. Our submission basically, my Lord, is that we are not saying, my Lord, that they are not married. It's not possible for us to say all of these things, my Lord, even though they have the burden to prove that they are married, but presumption nonetheless will exist, my Lord. Presumption in our favor of marriage, presumption in their favor of marriage, we have to examine. Now what we are saying, my Lord, with respect to our marriage, first of all, there is presumption. This presumption is strengthened by the fact that we were paid maintenance. My Lord, that's the first one. Supreme Court judgment says, my Lord, that maintenance under 125 can only be paid if there is marriage. Then the second, my Lord, we are saying is form number 7, that GIS form, my Lord, which the High Court also has actually accepted, and in which we have been mentioned as the wife. And the third one, my lord, we are saying is the will, my lord. In the will, we have been mentioned and it was probated, and that did not get challenged. And also, my lord, in the legal notice, the respondent has specifically mentioned that we were the first wife, but she had claimed that we were divorced, even though there is no divorce. So,
By the way, while you're at that, regarding that will, has anybody mentioned D1, D2, D3 during their deposition that there is also a will?
no, they have not mentioned.
Why?
She mentioned. Only D1 mentioned, my lord.
Was it exhibited?
Exhibited. In fact, the will was exhibited as Exhibit D9.
D9, okay.
Yes. And the order in the will was exhibited, the probate order was exhibited as D10.
D9. But it just says D9.
D9 is the will, my lord. Will dated 3/6.
That's correct, but where is the deposition to this effect?
The deposition was made by D1, my lord.
Exactly. So where in the deposition?
No, Exhibit D9 is it's the exhibit number. Exhibit D1, my lord, in the deposition she had mentioned, my lord, at page number 128. Page number 127 it starts, paragraph number 11. Page number 127, paragraph number 11.
Now, after that will was probated, it was challenged or what?
It was not challenged. In fact, that probated will was mentioned in the first RFA. And also in the, it was mentioned even...
RFA means the appeal filed by the present appellant.
Yes.
Challenging the heirship certificate.
Yes. And also in our counterclaim in the lower court, we had mentioned in the written statement. And we are also saying, my lord, this presumption is strengthened by the RTI reply which we received. The department specifically stated, my lord, that there is no divorce as per the official records. So what we are saying, my lord, that presumption in our favor is not just the presumption, it is strengthened by all of these documents. Now we are saying, my lord, the second wife, if our marriage is valid in the eye of the law, the second wife, my lord, first of all, cannot be a valid marriage simply because in Mizoram society, in the Mizo customary law, my lord, 2014, at section 10, it specifically says, my lord, second marriages are void ab initio. That's the first, my lord. And the second is, my lord, CCS conduct rules, because ultimately we are dealing with pensions, which is a service matter. CCS conduct rules, specifically Rule 21, my lord, specifically mentions that it cannot be done unless permission is granted by the department. Now, permission is not granted in this case. So what we are saying is, my lord, in the eye of the law, the second marriage cannot be accepted. So that's basically the crux. And there are Supreme Court judgments, my lord, we'll produce on Thursday.
All right. Please write hard in part. List this matter again on 23/2025 for hearing in the Part 1 cost list, so that we can give some preference to this. Yes. Few matters have been fixed on that day, so we'll take up this matter first.